Yes.
Listed to serial number 3, my lord.
No. Page wise we will take it.
Your Lordship, memo for posting. The family court has ordered to video calling to the child, Your Lordship, every alternative day. Since the child has eye problem.
On Monday, yes.
Kindly have it tomorrow, Your Lordship.
Not possible. Monday.
Please.
My lord,
Obliged.
date has given price, my lord.
Huh?
Not posted yet. Price date has given in this honorable court, but it is not.
Which year is that?
Pardon?
Which year is
24, my lord.
take that? Post it on Friday. Next Friday, not tomorrow.
MFM, my lords, challenging the order passed by the election tribunal, my lords, wherein CPC's order 6, my lords, wherein affidavit is mandatory. It has been stated by apex court as not mandatory, my lords.
Not in the legal question. When is the order?
Lords,
When is the order passed?
lords, it was passed and notice was issued. It is pending for admission, my lords.
Impugned order, when is it?
It was passed in the month of February, my lords.
We'll see. Take it.
My lords.
Yes,
My lords, the matter is coming before the trial court on 18th.
it is like this. I'll be coming like this. Everybody shouldn't come back again. Yes,
My lord, the serial number 31.
come this side. Yes,
The arguing counsel is,
not serial number. No, first the
Lordship,
memo,
kindly.
then the page was admitted.
Lord, I am a caveator. Though copy was not served to me.
Yesterday's not. Take that, post it tomorrow.
one matters,
Great.
one matters, my lord, is raise the office objection for more maintainability, MFA CPC. So I will mention the title sheet, the matter posted before this court for maintainability, but even till today is not posted, my lord.
Find out why it is not. If it is, post next Friday.
My lords, this is an MFA. I'm the appellant. I have prima facie proved that I'm the owner. Yet an interim order has been passed against me, passed in the month of July, my lords. Any date next week, my lords.
Notice is ordered.
No, my lords, fresh.
It has never come up.
No, my lords, fresh matter.
Objections are complied with.
I will, I'll comply.
If office objections are complied with, then it will come tomorrow or whenever
Please.
it is complied. Yes,
My lords, the matter is coming up before trial court on 18th of this month. Maybe posted tomorrow.
which year is that?
Fresh matter, my lords, maybe.
Tomorrow. Yes. Page wise.
Serial number 1, my lords, 2 weeks time making.
How can you make a mention for serial number 1? Can't you wait? Yes,
Page number 2.
Sorry, serial number 2, man. Sorry,
yes.
the matter is sit down tomorrow or
No,
mediation.
that 1 and 2 will reach within 1 minute. Please wait.
Page 2, serial number 6 to 11.
My lords, item number 8 and 8.1 appear for the respondent, right, my lords, request for an adjournment, my lords.
Request time. Have you informed the other side?
Yes, my lords, they are present, my lords. Petitioner counsel is present.
At the request of land counsel, the respondent, pose this matter on 14th of October.
Please, my lords.
Anything that is adjourned, it will not be posted in September. It will go to October. Just think about it and ask for adjournment.
Please, my lords. Great.
Yes.
Page number 3, serial number 12 to 17.
Serial number 13, my lord.
30.
Number 13.
Huh.
For the appellant in this case. Personal inconvenience, my senior, one of the relative expert.
Have you informed the
I
respondent?
will inform.
Narayan
No, I
Patel.
will inform and tell. Wait for your turn. Yes,
Please.
Serial number 15, my lord.
Page number-
yes.
MFA 2931. Therefore, the appellant is my lord. Settlement drafts are being exchanged between the parties. I request either on 21st or 23rd, my lord. On this one.
Where is the, your for the respondent? Both the councils submit that the settlement talks are going on. Post this matter on 15th of October.
Not shorter date, my lord.
No shorter date.
Date two.
Yes.
Page number 4, serial number 18 to 24. Page 5, 25 to 30. Page 6, serial number 31 to 34.
My lord, appearing for Art 13, serial number 31. The arguing counsel is unwell and we have informed both the appellants and also the other respondents both yesterday and today, my lord, requesting a shorter accommodation.
At the request of land counsel, the respondent post this matter on 21st of October.
Much obliged.
Page number 7, serial number 35 to 37. Page 8.
My lord, serial number 36, my lord, the matter is set down for further cross examination of PW1 today, my lord. Therefore, my lord, we have to cross examination of PW1. We are defendant appeal. On 4 weeks time may be granted. Already evidence was commenced, my lord.
for
No
that
interim
reason-
order in this appeal.
That reason why this matter should be adjourned.
But this is the appeal, my lord, we filed.
Huh.
That is the trial court already fixed the cross examinations, my lord, that
No,
3
this is-
dates
This is
completed.
independent,
No.
that is different.
There is no interim order. I have filed the appeal. And one short date may be given, we will complete the cross examinations. my lord. Today is the cross examination day,
What
further
if-
cross examination.
No, how it will come in your way? You
Ah.
have to go to that court,
Yes, yes, please. my lord.
pose this matter on, at the request of non-counsel, the
Some
appellant,
4 weeks time may be
On
granted, my lord. We will.
October 28th.
Yes, please.
Page number 8, cell number 38 to 42.
Serial number 39, my lords. The 2 appeals filed, my lords, only one has come up today. Can you taken up along with the other, my lords? The other one is
Post along with so and
Copies,
so.
your lordship copy is not served.
First, serve copies on him. Then counsel for the appellant shall serve a copy of the appeal memo on the counsel for the respondent. Post along with so and so. Any urgency?
urgency is there, my lord.
Post along with so and so on 19th. Yes,
Page number, page number 9, cell number 43. Page 10, cell number 44.
My lord, serial number 13, my lord. I have informed the Narayan Bhatt, sir.
you have
colleague.
informed.
Yes, ma'am.
13.
Please, ma'am.
What the court officer says is on the last occasion also you have taken
No, my
adjournment.
lord, just now. I
That
got-
time you didn't inform him and you have taken adjournment and you informed the court that you informed him.
No, my lord, just now I can't, his colleague, my lord, for that
It is
reason.
at the request of learned counsel for the appellant, pose this matter on
Serial number.
13.
on 21st of October. It is submitted that they've already informed the counsel for the respondent.
Interim order to be extended.
Huh?
Interim order to be extended.
Interim order earlier, you have an interim order.
Please, ma'am.
Then pose this matter on 30th of September.
Please.
Yes, interim order earlier granted is extended till the next date of hearing. Yes,
Serial number 3 in the second list, my lord. With regard maintainability, I may permit to withdraw, my lord. I have filed the criminal petition. Office has raised the objection. Hence, I filed the RPFC.
oh, that is, I think you have argued this matter earlier.
Started argument. Yesterday it came up for consideration. Serial number 3, my lord, second list.
What is the impugned order in this?
So when my daughters and son attend majority, they filed a petition under section 125. I filed a petition stating that since they have attained majority, they can't maintain petition under section 125.
Mm.
That was rejected by the family court.
Mm,
Hence, I prefer the criminal petition.
mm.
These has raised an objection stating that RPFC is maintainable, criminal petition is not.
No, why RPFC is not maintainable?
Because it is not an interim order, my lord. It is not an interim order. My application for dismissal of 125 application came to be dismissed. It is a final, it attained finality. So trial is going on there. 125 for.
We'll see this. Yesterday I've seen it.
Yes,
I have some doubts on that. That's why I didn't, otherwise I would have given permission yesterday itself.
yes, madam, please. Sir.
We'll see that. Yes. Call the list. Yes. Yes. Which one? We'll see. This two, you can call it at 2:30 along after those matters. Yes.
This one. For preliminary review, 1.
Hearing for
Devana
petitioner.
Sundar.
Why you want adjournment?
Senior is suffering from high BP
Ganesh
and
Kumar.
What is this appeal, writ petition? Let's see.
petition for enhancement of interim maintenance.
You want to post this
Modification.
matter on the top of the list on 12/9/2024.
Because senior is admitted in the Card Road Hospital. She is suffering from high BP and sugar.
Whether it is submitted that the land
2
council
weeks.
for the petitioner is not feeling well. Post this matter on 21st of October.
Cell number 2. Rajan MS. For petitioner. Bhushani Kumar.
What is this matter about?
Challenge the quantum of interim maintenance,
How much is granted?
10,000 is granted.
Huh?
10,000 is granted.
Uh,
This put by way of interim order.
Hmm.
Said I should go on paying rupees 5,000 per month.
You are paying,
I'm paying that.
is paying?
Is paying, there's some arrears that will work out. Tomorrow, the matter is placed before the mediator for mediation,
This matter?
this matter.
Oh.
If it is sorted out, I think.
Both the parties submit that the matter is coming up for mediation tomorrow. Post this matter on 15th of October,
15th.
Interim also.
15th of October,
Can it be earlier or beyond, up to 21st?
22nd of October. Yes.
Interim.
Interim order earlier granted is extended till the next date of hearing. Yes, next.
Sale number 3. Srinivas,
Appear for the petitioner, my lords.
Respondent.
Rangnath Joish,
Appear for respondent.
Petitioner is the husband, my lord. The petitioner is assigning the interim order passed by the honorable family court granting the interim maintenance of rupees 20,000 per month, my lords.
Hmm.
My lords, on the earlier occasion, my lords, the honorable court was pleased to grant an interim order of stay directing to deposit 10,000 per month. We have already complied that order. My lords, the salary certificate is produced at annexure F, page number 32, my lords.
And what about the arrears
Arrears also deposit.
deposited?
Arrears are deposited.
You have withdrawn?
Yes, ma'am.
Yes.
Salary certificate is at page number 32, annexure F, my lords.
How much? What is the
32
date of this? 32 is your date.
1st July 2022 at the top, my lords.
Hmm. So your salary is how much?
31,218 net salary.
No, madam, 43,000.
Gross 43,164.
Where do you get it? I'm not able to find.
Madam,
out.
Bottom, my lords.
Bottom.
In the bottom last line.
Huh, 43,000.
164 is the gross salary. And after the statutory deductions, my lords, net salary is 31,218. That is at the last portion.
What are the deductions?
Deductions, my lords, towards provident fund and
Education fund,
towards PF, my lords.
festive
PF and
advance,
tax.
PF advance. And PF interest, yes. So your salary is 31,218. Now
Yes.
how much the court has granted?
20,000, my lords.
20.
20,000 has been granted.
Please come to the order of the court.
Please, that is at annexure H, page number, the relevant portion is at page number 55, my lords. 55.
Let's, please read it.
On perusal of the, that is the second paragraph of the order. On perusal of the pleadings of objections to IA number 2, it reveals that there is no dispute regarding the relationship between the parties. And it is also not in dispute out of their wedlock, 2 children were born, daughter by name Nikita and son by name Bhuvan. The said Nikita died on 2018 and the respondent husband for no reason deserted the petitioner wife from the child. On perusal of the documents produced, makes it very clear that the respondent is working as traffic controller and the salary slip for the period 1st July 22 is produced, wherein the take home salary is rupees 31,000.
Yes, I've seen.
Yeah.
Hmm?
They assumed,
What agreed?
they agreed 43,165, 164.
No, 43, on the take home salary is
Hmm.
31,218.
Yes,
And
ma'am.
all those deductions are not any.
Now the present period salary is not paid. My lord, I have produced along with my statement of objection. ma'am. Next, kindly
What's the
see,
present salary,
kindly,
take home salary.
minimum salary, how much, our help, they have to say, man.
As on the date of the adjudication of the IA, my lords.
That is correct, but
When
my
he's
lord,
saying something, you have to tell the court, why would he say? You are saying that now the
My lord,
salary is more than
kindly-
what it is.
kindly annexure A2, page number 8, madam.
Page number?
8, I have filed a statement of objection, annexure A2,
When have you filed?
art, on 22nd July.
Hmm.
I have sought for information under RTI, madam.
Hmm.
They have denied. I am the third party, therefore information is not provided. That is,
We have sought for the recent salary slip.
yes, ma'am.
How much it will increase from July to September?
Kindly, I request petitioner, madam.
No,
Kindly
no.
provide
The salary slip is of which year? Which month?
22,
22,
on
madam.
the date of adjudication
From
of the
the-
IA.
This is
2020.
which year? 2024?
Yeah, now my 2024. I have
Order
produced
is when? Order is when?
2024, madam.
Why you have produced a salary slip of 2022?
My lords, when I filed the objections, my lords, to the IA.
Please come. The petitioner shall place before the court the latest salary slip basing on which further orders will be passed. Post this matter
Yes,
on,
Yes.
on 20th. Yes, next.
Sale
Much,
number
much
4,
obliged.
sale number 4,
Yes, sir.
petition,
125 proceedings.
Hmm.
Earlier,
How much is the amount grant?
no. The maintenance application which was filed along with the main petition was allowed ex parte in the initial stage itself without issuing the notice to the respondent during 2020 Corona period. Subsequently, I appeared before the court. I brought it to the notice of the court that the petitioner is living in adultery by producing all the photographs, and also filed an application for modification of the order and recall of the order, and requesting the court to give me an opportunity to put forth my case. The court has stated that since the application itself was allowed ex parte in the initial stage itself, you cannot file any application, interim application for modification unless it is challenged. Therefore, I have come before this honorable court. Your
What
lordship,
is the order?
order is of, kindly turn to page, that is the order sheet, and also the order, page 29. It was filed on 22/1/2020.
20?
22/1/2020.
Hmm.
Your lordship may kindly turn.
When did you, when did you enter appearance?
I entered appearance subsequently.
Date is relevant.
Kindly see page 30. That is the application was allowed in its entirety.
That's what we take it, that it is an ex parte order. Then,
Then
when did you enter appearance?
I appeared that on 11/1/2021, page 35.
Then when did you file the application?
Same application. Subsequently, I filed an application seeking to permission to appear and recall the order dated 27/10/2020. Objection was
When was it, when was that application on the same day?
on the same day. Application was allowed for recall of the order dated 27/10/2020. And subsequently, I filed modification application.
That order is recalled.
The order is not recalled.
That's what I'm saying. When is the date?
That date is order dated, your all lordship may kindly peruse 35, page 30. Is recall of the order, objections to application and objections to main petition by 3/2/2022.
So let us take it as 1/12/2021.
21. And on that day, the application was not filed. Now subsequently, your lordship may kindly see on 19/10/2023, page 39.
Hmm.
That is to set aside ex parte order. On that day, I filed an application on 19/10/2023. An application under 125 subclause 5 was filed. Bringing to the-
So, an order when you have entered appearance in 2021, on 19/10/2023 is the application.
application.
What will you do? So now, an order which is passed in the year 2020 has no, a writ petition will be filed on that order.
No, he made an attempt. He made an attempt. to
But
bring-
that attempt is also after 2 years.
Objection was filed, but unfortunately, with respect to this honorable court and with respect to my brother, that application was not filed by the council. Therefore, on the appearance of the another advocate, an application came to be filed. I fairly admit. But the lordship may kindly see the order dated.
Because there is no limitation for filing filing a writ petition, that doesn't mean that whenever
I
the,
fear this is ex facie prima facie, without giving opportunity to the respondent.
that is what we
Application itself was
accept.
allowed.
Let the court accept that was an order, then you should have availed the remedies available to you,
That-
not whenever you want to.
I-
So in that, we will not stay any of it, to please take notice to the respondent.
May I submit? Kindly turn to the photographs. Now 15,000 rupees has been ordered. 15,000 rupees including.
That order was operating against you from a long time.
5,000 rupees was granted to the major
daughter who is residing in Dubai. Now she says, you are not, for a moment, your lordship may kindly turn to the photographs. Kindly turn to the photographs.
Yes,
The divorce petition on the ground of adultery was dismissed.
please understand, Mr. Counsel, these are all on the merits of the matter that we will appreciate when the respondent enters appearance. Like this, we can't pass orders.
May
Your
I
Honor.
submit one more submission. Now, because of this order, now he had to undergo 1 month's imprisonment. And he is a driver by profession. He is a driver by profession. He is having lot of other ailments. I have brought it to the notice of the trial court also. And kindly,
The court would have appreciated all this when you have,
No.
if you had come to the court
trial
at an
court-
appropriate point
What
of
the
time.
trial court stated, since the application was allowed ex parte in its entirety, only thing is that it has got to be challenged. And unless it is recalled,
I don't think that the court has to tell you all that. You also know that. Whoever is appearing on
ex
behalf,
facie prima facie
he has
is-
he has a legal advice also.
it is on its face itself, without giving opportunity.
We will grant you a week's time, then we will list this matter next Friday. And by that time, you please get, because court can't pass these kind of
May I
orders.
may I kindly turn to the photographs. These are all.
That's not what we can
No, kindly turn to-
appreciate
It
now.
is all relating to her behavioral pattern.
Okay, no, without even an opportunity to.
No,
decide, we
these
can't-
photographs were produced, were supplied to them to say.
That's why let them come by next week, then we will appreciate everything. No interim order at this stage. Land counsel for the respondent is permitted to take out notice on the council, appearing before the trial court for the respondent and file a memo to that effect by 19th of September. If the memo is filed, pose this matter on 20th.
Part that matter, cell number 5.
I appear for appellant. This is the
Directed.
appeal may not. Yes, the impugned order.
Why is
passed
it
by-
adjourned on the last occasion?
No, it was adjourned only because of my friend was appearing in the VC. That video was not properly connected.
Yes, please argue. Or we'll have it at 2:30.
Please.
2:30,
Please.
yes. Next.
Cell number 6.
Petition.
Mr. Dhanush.
Yes.
I have filed my wakalat today on the counter, please. I request some time to file my objections.
You have an interim order?
My kindly give no, my lord, there is no interim order. It was a 2023 petition. They have been watching throughout, my lord. Even the respondent notice when we have served, they have not taken. my
Let's
lord.
see what is it.
We have served.
They filed any execution?
Yes, my lord, they have filed the execution.
Now, if you want time, don't press for the execution. We'll give some other date as per your request, or else we'll hear the matter.
Please, Madam. I won't press.
Land counsel for the respondent submits that the respondent is not going to press for the execution till the next date of hearing. When do you want?
Any date,
Pose this matter on 20th.
please.
Yes, next.
Cell number 7. Raja.
Lord, on last occasion, please, my lord. Respondent sought time to seek clarification with respect to the salary.
Yes,
My lord, it has been clarified. But in the order itself, it has been clarified that
no. Whether the order clarifies or not.
respondent is taking salary of 12,000, but it is not sufficient to lead the life of the.
That I understood from the order.
Please,
It is for you to say that you are working. Your contention is you are not working. How can the court be so silent about it?
as of now, she is not.
Let us see your petition. What did you say?
But,
And your contentions?
my lord, it has been stated that I am not working
And then
because
a party
because
who
of his
comes to the
always-
court.
he's always threatening the petitioner, threatening the respondent, and he is making galata in the company. That's why I'm not able to work.
Please understand,
Please,
if you don't come to the court with clean hands, court has no obligation or it's a duty of the court to discourage that kind of litigation.
Please.
No, you are not entitled for any relief from the court. I'll set aside this order. Let the court go ahead with, and also for your false statement before the court, let the court initiate perjury proceedings against your client.
she is a,
Not she is not innocent.
no, she is the innocent lady because they have
But the
given,
innocent lady will
they have given,
lie
they have
before the
given,
court.
they have given so much of torture to her.
That is a
the-
different
The
aspect.
criminal case is,
If they have
criminal
given it-
prosecution is pending before the magistrate court in Bangalore, please. She's an
Why is she,
innocent.
why do you, no, you
She's an
know,
innocent
the,
person.
you know the
Worse
judgment of
by-
the apex court, you know the judgment of the apex court.
Please,
As per that, now, if you have suppressed any material fact before the court, you are liable
assets and,
for.
assets and liability has not asked by the trial
Uh-huh.
court. Assets and liability has not insisted by the trial.
No,
court.
there is an affidavit of you saying that I do not, I do, I am, I'm not
Along with
earning.
applications, he has been.
You have given evidence before the court stating that you are not earning.
No evidence has been given.
Huh?
She has not given any
No,
evidence.
that's your contentions. Let's see the
It-
order.
It is for the cross-examination of the petitioner. He has filed for diverse petition.
No, when an IA is filed, no evidence will be adduced.
No evidence.
Let's see the order.
Only on the basis,
See the order.
only on the basis of application, it has been ordered.
Application you must have stated
Please.
that I'm not working when
Please.
you are working as on that day. So what
On
what
behalf
should be
of her,
done?
I pardon before this honorable court. Because she is an innocent lady. She doesn't know what to say.
Then she will, then will satisfy this order.
Now she is in village mill. Now she is in village mill.
Huh?
Now she is in village. She is not.
Lord, court audio is muted, my lord.
In between, have a look at it, that new audio is being muted. Yes,
Please, I appear for respondent in two petitions.
what is this criminal petition?
Criminal petition as against my lords awarding interim maintenance in DV proceedings, my lords. Appeal is filed and then my lord's petition is filed.
How much is granted in the DV proceedings?
DV proceedings 20,000 was granted. And subsequently, my lords, in the matrimonial case, she files one more application, wherein my lords 30,000 is ordered. My lord, that-
So from both the proceedings, she is
both
getting
the
50,000.
proceedings, no, ma'am. It's now inclusive of 20,000, what is ordered in the DV proceedings. Family court while part,
Means, yeah, 20 plus 10.
no, ma'am.
Hmm.
Yes, totally 30,000,
Excluding that.
including
That.
including.
20 plus 10, 30.
So this might become infractor.
Now, my
The
lords,
First petition, because my lord, in
That
the
is considered in this order.
matrimonial case, my lord, we brought it to the notice of the court. The court said inclusive of the maintenance awarded in the DV Act, 30,000 is awarded in the matrimonial case on IA number 5. So that has been challenged in writ petition and thereafter in writ petition that has attained finality.
that,
So
that,
therefore, my lord, this petition which challenges the interim maintenance awarded by the trial court under the DV Act, it will not survive for consideration.
now in view of my lords, the finding
Subsequent
recorded by this honorable court,
Where is that order?
that order, my lords, is produced in
Lord, your lordship may kindly take 9.2, my lord. I think that is the only writ petition that would survive for consideration now.
You appear for the wife?
I appear for the wife,
Oh.
yes.
22 is 5 item.
Lord, the order on IA number 5,
my lords, 83, page 83, my lords,
83 of what?
83 of 9.2.
9.2 may be taken up.
83, before that, my lords, page 82, operative portion of the order passed by the family court, 82, my lords. Now, this order has attained finality by virtue of, my lords, the order passed in writ petition number 22006 of 2022 by annexure G, page 83.
Oh, that is withdrawn.
That is,
Appeal is
writ
withdrawn.
appeal is withdrawn subsequently. Hence, the order passed by the family court has attained
Oh,
finality.
okay.
Now, in that view of the matter, my lords, since the family court has ordered that, my lords, interim order is inclusive of the maintenance awarded by the
An
learned,
appeal against the family court's order.
not, my lords. The as against
May
family
not
court's
be
order,
maintainable, but anyway, they withdrew the writ.
That's what,
But-
I mean, so in a petition under 227, when an order is passed,
we
how
have,
is it
we
appealable?
have filed and then subsequently the
Oh,
office
that's
raised
how it's withdrawn. So
office-
the learned single judge's order
order
is
has
now
attained
attained.
finality.
Finality.
Now,
That's
in
what I was wondering and looking at it, how a
Yes.
appeal is filed.
now may I request my lords to kindly see page 82 for a.
Now we will close this first.
Yes, ma'am. That can be closed.
Give that 9 first.
Criminal petition 8186 of 21.
8186. First one, which one is it? This one. Where is the order in criminal petition?
Criminal petition, my lords, order. Page 14, my lords, is the ex parte order. Comment page is page 16. As against that, we have filed criminal appeal.
Against that,
Appeal
you filed
also-
a criminal petition.
Yes. Now, in view of
The
the
wife had filed agreed with the orders passed in criminal appeal number 70 of 2021 dated 9 September 2021. The husband is before this court.
yes,
Husband is before this court. Initially, wife had filed criminal MC number 32 of 2021. And she had filed an application under section 12, read section 18, 19, 20, and 21 of the Domestic Violence Act. And also an application under section 23, 23(2) of the Domestic Violence Act, directing, seeking a direction to the husband to pay interim maintenance of an amount of rupees 50,000 per month.
the last
Yes,
one.
No, that is 50,000 as the maintenance.
They have mentioned it as
That is
50
the
lakhs.
mistake, my lord. 50,000 is what is claimed, it's not 50 lakhs.
But still I read it as 50,000 because nobody can ask for 50 lakhs.
50 lakh, my lord.
50,000 per month till disposal of the case. An order came to be passed on 24/2/2021, whereby the court granted maintenance of an amount of rupees 20,000. Aggrieved thereby, the husband had filed criminal appeal number 70 of 2021. That was,
Dismissed.
Dismissed.
that appeal of the husband is dismissed by order dated 9 September 2021. Against that, the present the criminal petition is filed before the court. Well, where is the single judge's order in that?
Single judge's order is at page
Page 83, my lord.
3.
Where you will find?
It is in writ petition number 22058, 9.2 of 2023.
Page number?
82 is the order passed by family court. Let's see.
Thereafter, wife had filed
MC number 208 of 2021.
MC number
The
208.
husband files MC.
Huh?
Husband filed. for
Husband
that.
files.
Thereafter, the wife had filed IA number 5 in MC number 208 of 2021, seeking maintenance. And by order dated 28 September 2022, the court had granted, the court has held that the wife is entitled for interim maintenance of rupees 30,000 per month from the petitioner husband from the date of filing of the IA, that is on 2/9/2021 till further orders. This order is inclusive of the maintenance awarded by the JMFC in criminal MC number 32 of 2021. And also litigation expenses of 20,000. Agreed thereby, the husband had filed WP number 22006 of 2022 that came to be on by order dated 24th November 2022.
Dismissed.
This court had dismissed the writ petition. They've carried this in appeal on the appeal by filing the writ appeal number 582 of 2023. And the same on 27th June 2023, as the court had observed that in view of the settled principle, the appeal.
I filed a memo.
A memo is filed that the writ appeal is not maintainable, and they sought the permission to withdraw the writ appeal. In view of the same, the order of the family court has attained finality. In that view of the matter, nothing survives for consideration.
Lord,
Not seen.
Now
So
coming
far
to
as
the-
9.1 is
Nothing
concerned.
survives for, as that order has become final, this appeal filed by the husband has no merits to entertain, accordingly dismissed.
Lord, coming to 9.1,
Give that. 9 point?
9.1. That is 13976 of 2023.
So you have filed 2 writ petitions, wife had filed 2.
No, my lord, this petition was filed because the maintenance was not granted. I filed an execution case before the family court. The family court observed that since the husband is residing outside the territorial jurisdiction, it cannot execute the order. That came to be challenged, my lord, in WP number 13976 of 2023. Now, my lord, in the meantime, what happened, my lord, the husband filed an application under IA number 10 to cancel and revoke the order of granting maintenance, which was ordered on IA number 5. On the ground that I have contracted a second marriage. Now, on that application, on IA number 10, the family court orders that the interim order granting maintenance should be kept in abeyance from 27/12/2022. That order, my lord, on IA number 10 is challenged in 9.2.
So let's see first this 13976.
Now, 13976, my lord, it might, my lord, I would seek to withdraw the execution case itself because in 22058, during the pendency of the writ petition, Pursuant to the order passed by this honorable court, the husband has paid a maintenance of 4,50,000 of till 27/12/22. So from 27/12/22, my lord, now I
So
number
if at all
10.
something is there, you have to
Yes.
initiate fresh proceedings.
Yes, I'll file a memo to that effect, my lord, so that,
Take the memo.
Execution petition itself,
trying the execution petition itself.
Where is the order impugned in this 13976?
My lord, that is, my lord, at, page 103, my lord, of 9.2,
103.
of 9.2, 22058,
No, I'm looking at 9.1.
9.1, my lord.
order is at page annexure T, page 128.
128. No, I don't think it's 128. There is. No, will you look from it and we'll show this. That is 13th June 2023 order. The order.
Yes, my
dated-
lord, 13 June 2020.
Agreed with the order passed in. Execution case number 1 of 2023 dated 13th June 2023. The wife is before this court. When the matter came up for hearing, a memo is filed by the counsel for the petitioner stating that during the pendency of the writ petition, the husband has paid an amount of rupees 4,50,000 towards arrears of maintenance till 27/12/2022. In view of the said payment, the petitioner seeks leave of the court to withdraw the execution petition with liberty to file a fresh execution petition in the interest of, that is not required. For
Not
that
required.
period only you filed.
Yes.
No
No,
liberty
but
is
it was
required.
filed for the entire period. My lord, till further orders was the order.
Hmm.
So that time it was filed for the
It is
entire amount
submitted,
of
it is
maintenance.
submitted that the order of granting maintenance from the date of, from where it is kept in abeyance,
27/12/2022.
27/12/2020, 22.
Two.
22, the trial court had kept the maintenance order in abeyance, and that is questioned by them by way of a writ petition. Hence, hence they seek liberty to file a fresh petition, or to file to move an execution, once basing on further orders to be passed by the court in the pending writ petition. Accordingly, memo is taken on record, and the writ petition is dismissed as withdrawn, giving liberty to the petitioner to avail the appropriate remedy whenever there.
Execution case.
Execution also will have to be.
Huh? And
Execution.
accordingly, the execution, see now, what is the number?
One of-
So
Execution
and
case
so.
number 1 of 20.
So and so, so and so. Is closed. It has to be
Execution
closed.
needs to be closed.
That also will be disposed of as withdrawn by orders of this.
In view of the same, even the execution case number so and so dismissed as withdrawn.
With liberty.
Liberty that's already given. Yes, next.
No, for the
Now, what about
execution
this case?
my lord, with liberty has prayed one sentence, otherwise my lord.
With
tomorrow.
liberty as prayed for.
Yes. My lord,
My lords,
this
as
case, my
prayed-
lord,
As prayed for, in the event, my lords, that order is.
That's what I
certified.
recorded in the
Otherwise,
in
my
the
lords,
first,
they may come back and say, my lords,
that
There
they've
is
already
no-
recorded in the
Yes.
event now, subject to what
subject
happens.
to
in
what,
the-
my lords.
That's what
they
I
take-
recorded in
Yes,
the,
yes.
yes.
my lord, the present 9.2, my lord, is IA number 10, my lord, the order passed on IA number 10 is challenged.
In this
Page
particular
number?
matter, my lords, may seek for 3 days accommodation because the reason is this, my lords, we have sought for, my lords, some documents to show that, my lords, she has contracted some second marriage. So it is under transit, my lords. Of course, I have produced certain documents along with my application and objections itself.
We'll have it next Friday on 20th.
Please,
A week after that, 28th, I have some inconvenience.
27th, my lords.
27. It's March 27. Not much. 27.
Please.
At the request of learned counsel for the respondent.
Interim order may kindly be.
Interim order only granted is extended to the next date. Yeah.
There is no interim order. I was directed to pay 4.5 lakh. rupees.
Look at it. If there is an interim order, extend. If it is not there, not there. Yes.
I was directed to pay my lords 4.5 lakh rupees. I have paid that.
I was under the impression that the further.
If it is
proceedings
there,
was-
it will-
I stand corrected, my lord, if there is.
Yes.
My apology.
Yes.
Great.
Anyhow, even if you ask and the court grant,
Yes, they will.
a stenographer will say it is not there.
I'm deeply offended.
Cell number 10, N.K. Sideshwar, for appellant.
Respondent. Appear for appellate.
Yes.
This is an appeal
Manohar.
against the Millard order passed by the Millard trial court. Millard, an ex parte decree was passed, judgment and decree. Millard, I filed Millard a miscellaneous petition under order 9/13 of. Millard, that came to be dismissed, that order has been challenged. Your lordships kindly see, Millard, I have been residing in the address, that is Millard, door number
Ex parte decree
3411.
was on 25/10/2002.
Yes, Millard,
Suit is of the year 2000.
2002.
When did you come to know? Where is your IA application? Your affidavit in support of the IA, order 9/13.
Millard, it is in the LCR.
What did you say?
Millard, there is a delay, Millard, with regard to filing of this.
That's what I'm saying. No,
Yes, yes.
what did you say in that IA?
Yes.
How you come to know what has happened? If you have a copy of it, please pass on to the court.
With regard
You
to-
have the record, open it, that application, in the miscellaneous petition.
In condonation of delay application, I have stated, that is, Millard, your lordships kindly see in the paragraph 3 of the affidavit.
Read it.
Millard, I submit that I have not been received any summons in OS number so and so in view of the wrong address furnished by.
What is the suit for?
Suit for recovery of money. Addressed, furnished by the respondent herein. Therefore, I am not aware about the passing of the ex parte decree. I submit that on 4/11/2003, the bailiff of the court have visited my business place along with an order of attachment of movables passed in execution number 400 of 2003. Millard, only Millard, he came with the summons in execution, he came to know. That is the Millard, paragraph 4 of the affidavit. IA along with the miscellaneous petition. IA number 1, I think, condonation of delay, section 5 of Limitation Act. After receipt of the copy of the said warrant of attachment of movables, I surprised to see that the ex parte decree came to be passed on 25/10/2002 in OS number 3922 of 2002. For the first time, I came to know about the passing of the ex parte decree on 25/10/2000. In spite of my protest, the movables were attached and undervalued and attached properties. I have also lodged a complaint in this regard. I submit that immediately I applied for a certified copy of the judgment and other documents. After perusing the documents, I came to know the fraud played by the respondent for obtaining the ex parte decree. I submit that from the date of knowledge, it is 4/11/2000.
Yes.
Where there is no delay in the filing the petition.
Please come to the impugned order.
Yes, please. Millard, in the impugned order, Millard, the trial court in paragraph 7.
What is the trial court's finding on service of summons to you?
Yes, with regard to that aspect, service of summons is, Millard, the finding is, Millard, I refused the summons. The process server, Millard, he has refused the defendant has refused the summons.
Then what steps you have taken to examine the process server, or what did you do?
Millard, your lordships kindly see in the impugned order, paragraph 7, Millard, in page number 11 of the order.
Read from para 7.
Please. The petitioner has specifically contended that the respondent has committed fraud by giving a false address in the suit and obtained ex parte decree in OS number 3922 of 2002. According to the petitioner, in the said suit, summons were not served on him, and the respondent, in collusion with the process server, managed in submitting the report that he has refused to receive the suit summons.
The petitioner has produced the several documents for his residential address. We are not concerned the previous and subsequent residential address of the petitioner. My lord, it is very relevant. For this reason, my lord, your lordships kindly see, he was residing at, my lord, 3411 13th Cross, 2nd Main, KR Road, Shastri Nagar, Bangalore 28. My lord, in the address given, kindly see the judgment. The address furnished by the plaintiff, my lord, money is number 1134 instead of, my lord, instead of 3411 as wrongly mentioned as the door number 1134 2nd Main. My lord, cross is not mentioned. 13th cross is not mentioned. 2nd Main is mentioned and Shastri Nagar, KR Road, Bangalore 70. And we are not concerned with the
So
previous.
please come to the order, but the respondent has furnished his address in the, as number 1134 of Main Road, so and so.
Yes, yes.
PW1 in his in the cross-examination admitted that he was residing in the address given in his evidence affidavit as on 25, that is 3411.
Yes, 3411. I was residing at, my lord.
You were residing in that house from when?
Pardon?
You were residing in that house from when?
My lord, just at the time of, my lord, serving the summons.
So what you have produced before the court to show that?
My lord, I have produced the document. Your lordships kindly see exhibit, my lord, that is, my lord, certified copy of the order sheet. My lord, in the earlier instance, my lord, I have filed a complaint, exhibit P7. That is 4/11/2003. Courier receipt, my lord, and also, my lord, legal notice dated 13/6/2000.
Who is RW1? RW1 is the plaintiff.
Respondent. Respondent, yeah. Plaintiff is the respondent here.
That's what, plaintiff is RW1.
Yes, RW.
Please come to page number 12.
Please.
Please read that. RW1 in his.
RW1 in his evidence stated that on 27/2/2002, he had accompanied with the, my lord, bailiff process server east to the residence of the petitioner at about 9 AM. And he has also stated that the petitioner was present. My lord, it is the duty of the process server. My lord, why, my lord, he has to go along with the his client, that is the respondent. This clearly shows, my lord, he has made a fraud, my lord, in serving the summons. My lord, he was not in 13th Cross. There are.
You cannot examine the process server.
Process server, my lord, on the particular point of time, my lord, he was not well. That is the reason, my lord, he unable to, my lord, issue any instruction to the advocate. My lord, he could not, my lord, cross-examine the process server. That was the mistake, my lord, committed by the petitioner.
No, he must have retired long back.
No, my lord, during that relevant point of time, my lord, he was severely.
No, I'm saying now.
Now, my lord.
Now, if you have to do it, he must
Yes,
have.
my lord,
retired
I
long
will do, my lord.
No, that's why I'm saying 2002 is this, 2003, we are in 24. He must have retired.
My lord, I don't think so, my lord. If she is available, my lord, I will cross-examine the processor because.
What is the purpose, right? From
My lord, it is a recovery. I am not at all liable to pay the amount, my lord.
No, you have filed a miscellaneous in 2003.
Yes.
When was an order passed?
My lord, this order passed on, my lord, 27th October 2014. The suit is filed by the respondent. That is.
What is the suit? How much is the amount recovery?
1 lakh.
Amount, the total amount that the petitioner is due was 96 lakhs. I'll take your lordship to the last paragraph of the order that is passed. Why?
What did you recover so far?
96 lakhs.
Well, 6 check cases are pending, 1 convicted, and in Hosur, case was filed, and now that matter is pending before the Honorable High Court of Madras. There also, of course, the petitioner lost the cases and decree has been passed in favor of respondent. The background is, last page of the order, page number 6, why he could not. He also has stated that he has submitted the report. Bailiff has submitted a report, exhibit R12, and the signature is marked as R12A. The version of RW2 has not been challenged by the petitioner by way of cross-examination. Now, the reason that is stated is that he was not well. He was not well. There was ample opportunity to cross-examine. Even after that, that could have been done. It has not been done. Exhibit R6 has been produced. R6 has been produced where the petitioner, it is only on the basis of the address, wrong address, that is only 1134 and 3411. The main ground on which they come up before this honorable court is only that. Now R6 will clear that. In the last page of R6, the address that has been furnished. Just because there are so many cases, why this case has happened is, he cheated by opening bank account. He cheated the respondent by opening bank account in Bangalore in Srinidhi Cooperative Bank, stating that he is the proprietor of the concern and transferred money, transferred the checks, encashed the checks that was due to one signed check. That is the respondent concern. So it is on this background why a wrong address was furnished. It is not the case of the respondent that wrong address was given. In R6, the last page, the address that is furnished by the petitioner himself, an undertaking has been signed. R6, the last page where he has signed as executant, yes, money. The address that is given is 1134. This is the only ground that they have come up before this honorable court. Not even 1 rupee is paid back. Only to cheat the respondent. This is not only for this, and now he is a proclaimed offender because giving this address, there is already criminal cases filed where the bailiff as well as the respondent was threatened, they were detained, and they were locked in the godown in his office. Criminal case is filed. There also he has not appeared. Arrest warrant is issued, and now he is proclaimed offender because proclamation is already issued. And now, by filing all these false statements and false affidavits before the honorable court, and when 96 lakhs totally altogether in all the check cases, and when that is pending, one affidavit is also filed, a senior citizen's mother of the respondent's money is also taken away by the petitioner and comes up with false statements and states, this is the address that is.
What do you say about this?
My lord, this is only, your lordships kindly see, my lord, the judgment of
Not the judgment, let us take the undertaking given by you before the bank.
undertaking, my lord, it is not available.
No, please give it to him. You have a
I'll
copy,
give
give him.
My lord, that is, there are several cases against my lord, the
Please, your lord.
petitioner
I'll-
responded.
Here on the
I-
point of address.
I have
That's the-
furnished-
That's the only thing the petitioner appellant is harping upon.
My lord, how,
He has opened an account without.
Let him submit, yes.
my lord, there is a case and counter cases between the, my lord, the petitioner and respondent. My lord, several litigations were pending and disposed of
That
before
might
the.
be.
Yes.
You are on the point that your address is 3411, not 1134. Now, what
That
is
is the
this?
reason, my lord.
What is this then?
Shivamurthy money is also and so. Exhibit piece.
That exhibit P6, this has been referred to because it has been marked in learned civil judges court in Krishnagiri, Hosur. This, not this. Yeah, exhibit R6.
Right, this is the transactions, my lord, with regard to, my lord, these are all the different transactions. My lord, they are the relatives. My lord, your lordships kindly see the judgment. It is
The name
judgment.
of the appellant.
Pardon?
What is the name of the appellant?
Name of the appellant is Yes Money.
Please come, this is given by yes money. Let there be 100 transactions. Your address for each transaction is one
No,
or
no.
different?
My lord, I could not file any objection statement because I had already given NOC long back before Corona.
No,
Sorry, I could not.
come to this, the one which you're relying on, this exhibit.
R6.
Where will you get that 1134?
In the last page, executant money, yes.
11:34 seconds.
11:34.
Please come. This is a case where I will impose the costs also. The present appeal is filed. Questioning the orders passed in miscellaneous number 1037 of 2003, dated 27th October 2014. The appellant is the defendant in the suit. The respondent herein filed a suit for recovery of an amount of rupees 96 lakhs.
No,
No,
it
this
is
is
not
for-
96,
no, that is the
1,60,000. That is not true.
No, that is the total amount
No,
as per
no,
the
that is,
undertaking.
that is in respect of other transaction. So far as this suit is concerned, only 1,09,000.
I am reading it from the.
In the judgment also, you kindly see the judgment.
Where is the judgment?
Judgment and
Take it.
decree. My lord, it is only in respect of 1,60,000. Making, my lord, kindly see OS 3922 of 2002.
Paragraph number 2.
No, it is.
Order.
ಅಲ್ಲ ಸರ್ ಅದು ಇದರಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿರೋದು ನೋಡಿ 1,60,000. It is only decreed for a sum of rupees 1 lakh. Don't
This is
mix
the order.
with other transaction.
This
Please
is the
don't
order.
mix other-
This is the
My
order
lord,
of
it
the-
is not fair on the
No,
part
no,
of the.
no, not
My lord,
on-
whatever the.
Please
It is not
understand.
96
It is
lakhs. My
contention.
lord, your lordship.
The court has recorded it.
Yes, yes,
I am
please,
reading it
your
from the
lordship kindly
order.
see. Yes.
So there's something, why do you blame him? Court has recorded it as 96 lakhs.
That is only the contention of the.
You will see at page number 2.
No, my lord, decree is only in respect of 1
No, I am looking at it.
60,000.
Don't
That is
worry.
the reason.
Where is the degree?
Judgment and decree, you are kindly see the judgment and decree. It is only in respect of my lord 1,60,000.
In this case.
It's only the contention of the respondent, that second paragraph.
What
The
is
total amount was 96 lakhs and several other cases are
The-
pending. Several other cases
The
are pending.
respondent herein has filed a suit, OS number 3922 2002, for recovery of an amount of rupees 1,60,000. The said suit came to be decreed on
2510.
25/10/2002.
2002.
On 25/10/2002. As the notices, as per the process server, the respondent had refused to, the appellant defendant had refused to receive the notice. He was set ex parte and an ex parte judgment and decree was passed. Thereafter, the present application miscellaneous number 1037 of 2003 is filed by the appellant to set aside the ex parte decree dated 25/10/2002. In support of the application, in support of that, an application, an affidavit is filed stating that. Anita, where is that affidavit of, first I've seen, no, not this affidavit. Affidavit in support of that.
IA number 1.
That is the one I have filed an affidavit stating that the defendant had not received any summons invoice number 3922 of 2002 in view of the wrong address furnished by the plaintiff. Further, it is stated that on 4/11/2003, the bailiff have visited the business place along with an order of attachment of mobiles passed in execution number 400 of 2003. After receipt of the copy of the said warrant of attachment of mobiles, then the plaintiff had come, the defendant had come to know about the ex parte decree that was passed on 25/10/2002. It is the case of the defendant that for the first time, he came to know about the ex parte decree on that day. Immediately he applied for the certified copy of the judgment and has come up with this petition. From the date of knowledge, that is on 4/11/2003, there is no delay in filing the petition for setting aside the ex parte decree. In any event, if there is any delay, the same is caused due to the above stated facts and circumstances. Hence, it's prayed that to condone the delay in filing the petition, if the delay is there, and to set aside the ex parte decree. The court, by order impugned, dated 27th October 2014, had dismissed the miscellaneous number 1037 of 2003. By order dated 27th October 2014. While dismissing the same, the court has observed that RW2 is the process server, has stated that, invoice number 3922 of 2002, the smooth summons were entrusted to him by the office of the court. He has also stated that he has submitted the report as per Exhibit R12 and his signature is marked as Exhibit R12A. The version of RW2 has not been challenged by the petitioner by way of cross-examination. The court observes that there is no reason to disbelieve the testimony of RW1. Considering the material on record and discussions made thereunder, the court had dismissed, the court felt that there are no reasons to restore the suit. Land counsel land counsel appearing for the appellant submits that the address that is mentioned as is in the suit is 1134 Second Main, Shastri Nagar, KP Road, Bangalore, whereas he is residing at 3411.
13th cross.
At number 3411, 13th Cross, Second Main, KR Road, Shastri Nagar, Bangalore. And council submits that itself goes to show that he is not residing in the said building. The question of receiving summons from the court will not arise. Then he has also submitted that RW1 in his evidence stated that on 27/2/2002, he had accompanied the court bailiff process server to the residence of the petitioner, which clearly shows that there is a collusion between the plaintiff and the process server. It is submitted that as on the date of passing of, at the time of considering this application, the plaintiff was not feeling well. As such, he could not cross-examine the process server. It is submitted that as he has no knowledge about the pending suit, there are on that ground, the court ought to have set aside the ex parte order, passed ex parte order, ex parte judgment and decree dated 25/10/2002. Next paragraph. Land counsel appearing for the respondent plaintiff submits that there are several transactions between the defendant and the plaintiff. The total amount is 96 lakhs. Several cases were filed by the plaintiff. It is the case of it's a case of the plaintiff that in the miscellaneous application, Exhibit R6, an undertaking which was given to the bank, was filed, wherein it clearly shows that he is residing at number 1134 Second Main, KR Road, Shastri Nagar, Bangalore. It is submitted that the defendant had the defendant having taken the money from the plaintiff, and as though several proceedings are pending between the parties, is evading to pay the money by one means or the other. When he is very much residing in the said premises, now he has put forth a case stating that he is not residing in the said place and the summons were not served. He submits that when the process server was examined on behalf of the plaintiff, the defendant had not chosen to examine him. All this speaks volumes about the conduct of the plaintiff, conduct of the defendant, and how he is evading to pay the money and how he is litigating the matters. Next, and the trial court had rightly dismissed the court had rightly dismissed the miscellaneous petition filed by the plaintiff, filed by the defendant. Next, having got the concepts on either side, it is the material of the court. This is a suit of the year 2002 filed for recovery of money. It was decreed ex parte on so and so date.
25/10/2002. 25/10/2002.
2010-2002. It is the case of the defendant that summons are not served on him. According to him, he was residing in a house number 3411, but it is mentioned as 1134. 1134. As such, summons are not served on him. Court had considered the evidence of the process server, and the process server was not cross-examined. Then the court has come to the conclusion that the evidence before the court, the evidence of the process server was taken into consideration, and court had dismissed the petition. This court had perused the exhibit R6, which clearly shows that the address is number 1134. This is an undertaking given by the defendant to a bank, which clearly shows that the petitioner has come before the court with all the suppression and misrepresentation of facts. Now, a suit that is filed in the year 2002, which is decreed in 2003. Now, the MFA is in 2024, the MFA is still pending. Even before this court also, the very same contentions are put forth. When the undertaking, that is exhibit R6, which clearly shows that the appellant had come before the court with all false statements, the suppression of facts. Considering all this court is of the view that there are no grounds to entertain, there are no grounds to entertain this MFA. And MFA is dismissed with cost for ₹50,000.
Regard to caste is concerned. my lord.
What kind of a conduct is this?
No, this conduct is, my lord, several litigations for.
Maybe
My lord. that is
blatantly is
whatever,
lying.
My lord, your lordships, whatever, that exhibit R6, my lord, it is between the, my lord, he himself has executed that document. My lord, that is not the document, my lord, executed by the.
Who is money?
Money
Money
is,
has executed.
money and also, my lord, the respondent also.
Money is there in
Is
that.
there, it is, my lord, that was, my lord, at the instance of the respondent, that the document came to be, my lord, executed. That is the reason.
Why
my
did
lord,
you not,
that is-
why did you
my lord,
not,
several documents, my lord, I have produced. Kindly see exhibit in the.
the defendant has also not cross-examined the process server, and now coming up before the court stating that the process server is in collusion with the plaintiff. These kind of submissions cannot be considered. Yes, dismissed, remove the cause.
In another case, the bailiff was detained in the godown of the.
There is no
So that matter is pending.
Yes, yes, next matter, 11.
KB Taylor, for appellant.
I appear for the respondent number 4 in this matter.
Hmm.
So I'm not keeping well, my lords. I mean, request for a week's time, my lords. In this matter, there wasn't.
You're not well.
Please, my lord.
Who has moved the memo?
I have moved the memo, my lord. My lord,
Suppose this matter on 20th, it is submitted that the counsel for the respondent is not well.
my lord, I have moved for consideration of IA, my lord. They are
Hear
removed.
it finally on that day.
Please,
No further adjournments will be granted.
please.
For 12, the
Great.
other entity. For petitioner, appellant. TB Shivkumar.
I appeal for responding, my lords, kindly pass over my notes.
Password.
Password, we'll take up next week.
My lords,
Password
if you
and
kindly
some other.
passed over, my lords, the senior wants to make the submissions.
You have a stay in your favor?
Pardon me?
Stay is there?
No, not tested.
Suppose this matter on,
My lords,
on
submitted.
30th,
Macho.
the request of the uncounsel for the appellant. Yes, next.
Cell number 13 adjourned, cell number 14, C. Shankar Reddy. For appellant,
Respondent.
Venkatrami Reddy, for respondent.
Not at an earlier point of time, not this honorable court not was pleased to hear both of us. Not for the first time, before this honorable court, not the respondent could file in not the death certificate
Yes.
indicating. not
That is what you wanted to respond to. It is submitted with the land council, the respondent defend that one Mrs. A. Bose had executed the GPA. Land council, the appellant parenthesis said Ms. A. Bose died on 27/7/1987, and the policy had to place some documents before this.
Therefore, my lord, the case of the other side was that 5 years prior to the execution of the registered general power of attorney, the executant was already dead. Not that contention was not taken in the written statement. Not we wanted anyhow, not verify whether this particular document not is a genuine document or not. Now, it was issued by the the Calcutta Municipal Corporation. We made an application to the Calcutta Municipal Corporation. They've issued an endorsement that it is a fake one. That is the reason, my lord, day before
She
yesterday,
died on 1987, as you have said.
please, my lord.
When she died, verification letter.
Verification letter says that such kind of
Copy of the certificate
registration has
has
not
been
been done on
attached.
that particular day. There is no such registration at all.
Where is the document you are relying on?
Lord, they have relied
lord.
on, my lord, along with the
Date of
document.
document, date of death, you have mentioned 26/7/2087. Date of death as per the document is 27/7/2087.
Lord, your lordships may kindly refer to the document that they have produced along with the.
No,
This is a certified
That is-
copy.
we'll go to that, we'll go to that. Now, even as per, what is this, the above
Lord,
information?
copy of this
Hmm.
was made available to the corporation in order to verify whether such a my lord, death certificate has been issued by the corporation. Along with the copy of the letter that the other side made available to this court. Not we had affixed the same. Not there is some portion, my lord, was illegible. Therefore, my lord, I also requested them by filing a memo before this honorable court to produce the original before the court. That copy, my lord, is original they have to produce.
Page number?
Not in the documents that they have filed on 22/8/2024.
Page 34 of their objections.
22/8/2024, my lord, a list of documents were produced.
Page number 34, madam.
Page number 34.
34, which I have filed the objection.
34 of respondent.
The reason, my lord, the 22/8/2024.
That is on. What do you say?
I'll just ascertain this, my lordship. Date of the death is totally wrong, my lordship. Date of the death, what they have mentioned is 26/7.
No,
Actually,
you
it
are
is
saying
27.
it's strong based on this certificate. Where from you got this certificate?
From Municipal Corporation, Calcutta, my lordship.
Then why, what do you say about this?
Let them produce the original before the court. No?
Hmm.
Let them
Original is
produce the
come.
original.
Please come.
Because in the written statement, it is not taken up such a contention.
My lord,
First time, my lord, in the MFA.
no, I have filed a P&SC. This produced before the P&SC court, my lordship. This is the
Report
certificate.
on 28/2024 is passed in order. Wherein it is observed that according to the counsel for the respondent defendant, one Mrs. A. Bose has executed the GPA in the year 1992.
Even the terminology is also.
Hmm.
See once.
The learned counsel for the plaintiff submitted that she died on 27/7/1987, and he has filed a death certificate before this court issued with the Calcutta Municipal Corporation. Then the learned counsel for the defendant had sought time thereafter. The memo is filed before the
At short time, my lord, I am for the appellant.
appellant defendant.
Appellant plaintiff.
Appellant plaintiff. Learned counsel appearing, stuck of all that, learned counsel appearing for the appellant, appearing for the respondent defendant submits that one Mrs. A. Bose died on, died in the year 1987. Question of issuing a question of executing a GPA in the year 1992 will not arise. In support of that, he has he has placed before this court the death certificate of Mrs. A. Bose. As per that, she died in the year 1987. Then the learned counsel for the appellant plaintiff had sought for time. And today when the matter came up, he has placed before this court the communication from the Kolkata Municipal Corporation stating that the information, the copy of the certificate of death for A. Bose.
Date is mismatching, my lord.
Huh?
Date is mismatching. Date of death is mismatching.
There is matching. There is nothing it is.
Yes, my lord.
They've not stated anything. There is nothing to mismatch now. A. Bose that is being attached with the request. With the request matches the original. Something is wrong with this.
Not, the
It do not matches with the
language
original
that has
and the
been
no
employed.
records are there in their files. The certificate is invalid, not in issue. The certificate according to them, it's not issued by the Calcutta Municipal
Please, please.
Corporation. Land Council for the defendant seeks time when
One 20 days time may be granted, my lordship.
Post this
After vacation, my lordship.
on October 15th.
Cell number 15
I'll
adjourned.
produce a certified copy from there, my lordship.
Cell number 16, K.K. Vasan. Appellant.
After for the appellant.
Yes.
Appellant is the second defendant in the trial court. Where the first respondent has filed the suit for partition and separate position for 1/7 share on the ground that her father, Venkatappa, acquired all the properties and he died in the year 1991. And mother also died in the year 2000. And there was no partition in the family. And she is entitled to 1/7 share in all the suited property as many as 1 to 10 items as shown. But taking back the age of that the plaintiff is 72 as on the date of filing of the suit. That is in the year
What is the IA
2019.
he sought for?
She sought for non-alienation of the restrainment with regard to alienation of the suitable properties. So all the defendant contended that except item 1, 2, 3. All the properties are not in existence at all because these properties were sold by the father during his lifetime. Only this property that is 1, 2, 3, totally 5 acres something untas, was divided or settled by the father in the year 1983 in favor of his sons. And in the year 2004, there was an order of conversion, and in the year 2006, they went into joint development agreement. And the developer has developed the property and actually sold his share in the year 2007.
When was the development according to you?
Pardon?
When was the development?
Development in 2006.
Ah.
2007, the developer has sold all his share of the flats. And the different rate also sold all his flats except 2 flats. That is in the 2004,
Come
2006.
to the cost item.
Cost title of the plane.
Hmm.
That is your last will find at page 31. Sharadamma.
She is the plaintiff. You are which defendant?
I am the second defendant, that defendant number 2, G.V. Jairam.
Hmm. All the defendants are family members?
Yes, all the defendants are the younger brothers of plaintiff.
No, 7 is?
7. Yes. No, she is actually a wife of G.V. Devendra, that is defendant number 5.
Hmm. Hmm. Let's just look at the plain. What is the plain schedule property?
Scheduled properties are 1 to 10. That is at page 36. The total extent is 6 acre 6 acre 10 guntas and 2 acres 4 guntas and 1 acre 34 guntas has been made.
What is your case? This property is long back partition.
Yes, in the year 1983, during lifetime of the father, when it is said that the self-acquired property of the
Oh, this
father.
property, the mutation is in whose name?
In all these names of these persons.
Independently on all
Yes,
the family?
because they got it converted, they have entered into joint development agreement in the year 2006. I'm concerning about the item number 1 to 3 only, not beyond that. Because all other properties have been sold.
No, what is the nature of these properties, 1, 2, and 3?
1 to 3 are properties was subject matter of settlement in the year 1983.
No, what is the nature of it right now?
Now, right now is converted land in the year 2004 by Deputy Commissioner, and 2006 joint agreement was entered into, and the developer has built several flats and sold his share.
And now she's showing it as in the form of
It is
land.
agricultural land, she shows the agricultural land, it is against to the records. They must say, she must say that. How could she describe these properties as the?
You have filed anything to show that it is long back converted into a?
Yes, I have stated in the written statement itself. Written statement is page 41.
We'll post this next week, take a notice, we'll pass the order itself. We'll pass a final order. Take notice to the respondents.
Yes. It may be emergent notice, may be ordered.
You can take hand summons also. Bangalore,
Yes, it's Bangalore.
petitioner is permitted and counsel the applicant is permitted to take out hand summons on the counsel appearing for the respondents before the trial court, and shall file a memo to that effect by, when can you take? When you want. Date.
Within 8 or 10 days. Probably it may take that.
Post
But
this
from,
matter on-
they may not respond to this, my hand summons also.
Matter on 25th. If the memo is filed by 23rd, post this matter on 24th. Yes.
24.
Yes. Not required.
Cell number 2617, Ajay Rao, for appellant, Jay Narayan.
Appellant, defendant's appeal. No? Suit is one for partition. Plaintiff, my lord, is the brother of the defendants. 3 sisters are the defendants who are the present appellants. 4 items of properties in the suit schedule. Lord, item number 1 and 2 is a property which the appellant's mother acquires from her father by virtue of a registered will of the year 1978.
Item number
1 and 2.
1 and 2.
Please,
1 and 2 by the plaintiff's mom.
by the appellant's mother, even the plaintiff's mother.
That's you're the defendant.
I am the defendant. The
Defendant
sisters
mother has acquired.
has acquired. The appellant's mother has acquired the item number 1 and 2 property by virtue of a registered will of the year 1978. Item number 3 property was purchased by the mother of the appellants in the year 1974 by a registered sale deed. Item number 4, the appellant's mother acquires it by virtue of a partition between her and her brothers. Lord, all the 4 items of properties are, my lord, item number 1 is willed to the appellants by the mother. Item number 2
That
to
is
4.
appellant is defendant number 2.
Appellants are the defendants, 1 to 3.
That's what I'm saying. You said it is willed to the defendant
Appellants,
number.
appellants,
All the
all the defendants.
defendants are how many?
3, my lord.
So to D1 to D3, she has will.
Yes,
When is the date of will?
that is in the year 2001.
Ah.
Item number 2, she gifts it to the appellants again, rather the defendants, in 2015 by virtue of a registered gift deed. Now, item number 3, she gifts it again to the appellants by virtue of a registered gift deed of 2017.
All are wills
All
by way of will.
by way of gift deed. Gift.
Said will.
The item number 1 is by way of will of the year 2001. Item number 2 to 4 are by way of gift deeds. And item number 4, my lord, the gift deed date is 18/12/2008. Now, my lord, the mother passes away in the year 2017. Suit is filed for partition by the brother in the year 2018. But the impugned order gets passed, not whereby and it is a contention of the plaintiff that the father purchased the property. Father was also a businessman. He purchased the property in the name of the mother. Not one single document is produced along with the plaint to show.
What is there in the plaint? What did they say?
My lord, in
What
the
is
plaint,
there?
your lordships may take, my lord. The plaint is produced at page 40. I'm sorry, my lord, at page 34. No, I'm sorry, my lord. Page 34 is the IA, 23. My lord. In this paragraph number 9 is where he speaks about the acquisition of the properties. The plaintiff submits that his father was also a successful businessman and regularly purchased property.
Para number?
Para 9, my lord, page 25. The plaintiff submits that his father was also a successful businessman and regularly purchased properties out of his savings. The properties mentioned in the schedule below were purchased by him through his income in the name of his wife, late so and so. Plaintiff submits that from the date of the father's death, the plaintiff has been taking care of the mother, so and so. The plaintiff further submits that as averred above, by this time, his sisters, that is so on, defendants number 1 to 3, were married and were residing in the matrimonial homes with their respective in-laws and the respective husband. It is pertinent to mention that the plaintiff has been looking after and managing the joint family since 1983. So, apart from this vague government, Lord, absolutely nothing is stated as regards how each of these schedules.
No,
Yes.
please come again to this scheduled properties.
Yes.
Now, item number 1, you say that it is in the year 2001. No, that is purchased when?
Lord, it was willed to the defendant number 1 to 3's mother by virtue of a will.
So that I understood. You
Yes.
said item number 1, property.
Yes.
Is how she has acquired that property.
The appellant's, my lord.
The mother.
The mother through a will executed by her father, my lord, in the year 1978. 1 and 2. Item numbers 1 and 2.
Next 3.
Three,
You said she purchased it.
she purchases that through a registered sale deed of the year 1974. And 4, she acquires by virtue of a partition between her and her brothers.
How you were able to substantiate all this, saying that this?
My lord, I've produced, in my written statement, I've taken specific contentions and produced the documents. My lord, I've produced those documents along with the memo. In my written statement, my lord, your lordships will see. Yes. My written statement starts at page 41. At page para 11.
I'm looking at the documents. Come to the documents.
Yes, ma'am. But the documents which I produced, the first document, my lord, is the will of 1978. 78.
1978.
By virtue of which she acquires item number 1 and 2.
By her father.
Please.
He has it? Mr. Counsel, for you have that?
I tried to serve it to him, my lord. He said he'll receive it before this on.
Please look at it. We'll take up this matter in the afternoon.
Then
Pass
number
on.
18.
Very good.
Please look at those documents. Now, as far as that one property is concerned, item number 3, which is purchased by the mother, other 1 to 4, if what he says is right, then we'll vacate the order as far as that is concerned.
We've been served the copy a week's time ago.
No,
and
no,
we
my
have
lord. I have
filed
served the
the
copy on to him.
You are a caveator.
No, my lord, we are the respondent. The copy was served on us a week ago. We have filed wakalat. My lord, just on 10th. Now that we had filed an order application and order 39 rule 1 and 2, the same came to be allowed. And after the delay of 783 days, they have come up to vacate the order which was passed in affirmative, 39 rule 1 and 2. After 700.
Anyhow, they have come here. Yeah, anyhow, they have come here. Are you ready to argue today or not?
My lords, we seek time to file objections to the main petition, item number 1 and just 2 weeks time.
Post on 20th Friday. We'll hear on that day and
Very-
dispose of. At the request of land counsel for the respondent.
Great.
Then number 18. Shirley Hegde.
File number
Here for the appellant
213 in this
counsel.
case.
This is a plaintiff's appeal, notes.
Raghavendra.
That's file number 213 in this case.
Yes.
That's on an IA for temporary injunction which has been rejected. Suit is for declaration of title and injunction, my lords. My lords, one condition, apart from the merits, what I would like to bring to your lordship's kind notice. These very same defendants, lords, we claim sites having been allotted by a society, my lords, which formed the layout. BDA, that's the Bangalore Development Authority, which had formed the layout. Now, my lords, we have 2 sites in our possession.
there were adjacent sites. Now, my lords, the defendants, that is the respondents herein, more so, my lord, the second and third respondents who are
There
now
are any batch matters?
not here, my lords. But what happened is these very same defendants tried to interfere in respect of adjacent sites. Now, my lords, on that suits were filed by those site owners. And the
Some order is passed.
trial court passed an order. This
After that, another Learned Single Judge has passed some order.
granted a temporary injunction against the very same defendants. Matter went to the Honorable Supreme Court on the first round carried by the very same defendants. SLP was withdrawn seeking liberty to file
They
review
are the
petition.
society.
Let's,
They are the society.
no, they are the persons who claim to have purchased from the original landowners, though the sites have been formed. Lords, that order also was produced before the court below. If your lordship kindly come, my lords, for a moment at page 136, running page 136, my lords.
136, yes.
This is an order, my lords, judgment dated 23 April 2018 in respect of an adjacent site owner pertaining to the very same survey number. That was site number 411 and 416, which your lordship should get at page 137 for a moment, in which an injunction came to be granted. Now, the present respondents 2 and 3 filed a review petition against that. They went to the Supreme Court for the first occasion, came back to this court and filed a review petition. Your lordship sees this order. Review petition came to be dismissed, confirming the injunction. On all the grounds, the court considered about acquisition being quashed. Same, my lord, the second and third respondents herein filed a review which came to be dismissed on 3rd February 2020. They carried it to the Honorable Supreme Court yet again, which was confirmed by the Honorable Supreme Court.
No, that this order, no, the Supreme
I'm
Court,
sorry.
what you are referring to is by the society, I think.
No.
By these people who have
By
purchased
site
the
owners.
property.
Lord, what happened? One of these people claim that the acquisition has been quashed. And because the land vests with the original landowners, they say we have purchased the land. Whereas our case, which we have pointed out, is there were 2 bits of acquisition. One was in 1986, my lords, for about 164 acres.
What is the society from which you have purchased the property?
My lords, it's a house building cooperative society.
There must be some name to that.
Wildly Kowal House Building Cooperative Society. We have mentioned it. 164 acres was acquired for their benefit. Now, on the same day, that's in 1986, my lords, this was in Bangalore North, what is known as Nagavara village. Now, my lords, on the very same day, for the very same society in Bangalore South, the government had acquired another bit of land for them. Now, that along with some HMT layout societies was challenged before this honorable court. This honorable court held, my lords, that the acquisition, so far as that is concerned, is bad and quashed it on malafide, saying that there has been fraud committed. All, but that pertained to Bangalore South. Now, so far as Bangalore North, 164 acres, which was acquired, lords, about 52 acres was deleted. Either some people had challenged bits of that acquisition, only those bits were quashed. Some were denotified, about 54 acres. The society then went to the government, my lords, and said, we want to acquire this entire 54 acres, which has been denotified or quashed. So issue yet again an acquisition notification for this 54. Government issued a notification in 1999, 4-1 notification to acquire only this 54. Balance 160 or something was finalized. Now that became a subject matter of a litigation before this honorable court. Government did not proceed further. Society filed a writ petition seeking a writ of mandamus to complete the acquisition process.
That I have seen some other.
Yes, madam. During that process,
it is so single judge, I think the division bench said that we cannot issue such a directive.
Actually division bench and single judge granted a mandamus. Not it issued a mandamus, complete the acquisition. The landowners, my lord, some of the landowners who are known as Anjanappa and others, filed a SLP before the Honorable Supreme Court. Supreme Court said, not that you, first of all, you could not have done it. There can't be a mandamus to complete the acquisition. By the time you even issued this acquisition notification, the period between 4-1 and 6-1 had even otherwise elapsed. So if you have taken possession of this 54 acres, you hand back this land. That's the society should hand back. give the compliance report. So far as that 50. Now, insofar as this particular survey number is concerned, after the denotification, my lords, the original landowners had executed a private sale deed itself in favor of one Karyappa from whom the society took.
When is the acquisition in this?
My lords, the original acquisition, my lords, that's what we have pointed out. The original acquisition was in 21/2/1986 for 164 acres. In our synopsis, we have set out. My lords. Then, my lords, so far as
For how many acres?
164 acres, my lords. In the meanwhile, about 52 acres, 17 guntas had been dropped from the acquisition or quashed by this honorable court. Both, it comprises both. Now, my lords, the subject matter which they are claiming is survey number 34/1. Now, that acquisition had been quashed, my lords, about 1 acre and 8 guntas. So the state government, by virtue of a notification dated 28/7/1999, issued the 4/1 notification to acquire even this extent of land. During the pendency of that, the government did not proceed, and on 4/6/2001, government took a decision to drop the acquisition, not to proceed further. On 20th May 2003, the original landowners, my lords, sold the entire extent by virtue of 2 sale deeds in favor of one Karyappa, who was a representative of the society. And then Bangalore Development Authority, lords, approved the layout plan on 12/9/2003 for an extent of 98 acres, 21 guntas, which included 34/1, which is a subject matter. Because Karyappa, my lords, assigned it to the society. Then, my lords, ultimately the society formed the layout, sorry, my lords, and sold the first site, that is the Schedule A property, that is 404 site number on 4/4/2009 in favor of my vendor. Schedule B property is another site bearing 405. On 4/4, same day, 4/4/2009, it was sold in favor of one Srimati Shruti Hegde. Possession certificates were handed over. Kata changed by BDA in their name. When it came within the limits of BBMP, my lords, BBMP also changed the Kata. From them, I have traced my title and I purchased. My lords, I purchased the sale deed. I purchased it, my lords, on 17/3/2023 and 1/4/2023. 2 sites on different dates.
Before this, the sale is only in 2009.
Yes.
From them you have purchased, no in
Yes.
between sales.
No. So far as the sites are concerned. Now, my lords, thereafter, because there was an interference, I filed the suit. Now, in the meanwhile, what has happened is, my lords, the first defendant in the suit, she gets a gift deed from her grandmother, who, my lords, had originally sold the property, whose children, every family member had sold it in favor of Karyappa on 20th of May 2003.
So they are having only this land.
Only that. They say, we have purchased it. We say there was already, even if land acquisition is gone, there was a private sale.
No, according to them, that land acquisition is not there, the land vests with them.
Land vests with them is their case. Our case is on 20th of May 2003 itself, the original family members, the owners of 34/1 have executed sale deeds in favor of Karyappa.
Their contention in the written statement on that. on the
They
sale.
only rely on their entire sale deeds. Every document, if your lordship peruses, they only claim acquisition has been quashed by Honorable Supreme Court. Supreme Court has directed the society to.
Your plaint, you must have taken this ground.
My lord,
What
please
would you
come
say?
to the plaint. I have taken up. The plaint your lordship should get. It starts, my lords, from page 56. Running page 56, my lords.
Yes.
My lords, I have set out how I have acquired the title.
Please come to that particular averment with regard to this sale deed dated 20
Yes, my lords.
2003.
Now, please, at page 62, I have given the background facts relating to land acquisition. Your lordship sees. Thereafter, my lords, please come to para 19 at page 63 onwards.
Hmm.
Thereafter, the state government, your lordship gets it.
Yes.
The state government did not proceed further with the acquisition proceedings initiated under notification dated 28/7/1999 and instead passed an order dated 4/6/2001 deciding to withdraw the preliminary notification dated 28/7/1999. Then this action of the state government was challenged by Wildly Cowell House Building Cooperative Society before this court in so-and-so WP. Single judge of the Honorable High Court has allowed the WP by order dated 9/3/2004 and had quashed the government order dated 4/6/2001.
Come to 21.
Yes, my lords. It is submitted that during pendency of the aforesaid proceedings, original landowners, children of late Apoji and late Muniappa of entire extent of 1 acre 8 guntas of land comprised in survey number 34/1 of Nagavara village had sold the said land by way of 2 registered sale deeds dated 20/05/2003, one for 24 guntas and another for 24 guntas.
To the written statement. Now, what is the
Yes, ma'am.
reply to this?
And thereafter, the gift deed, if your lordship sees at page 68, I have set out about the gift deed also at page 68, para 31 onwards. Once the entire extent, I have said how the relationship also I have given at para 32. That para 32 I have said, everything was set out. Now, my lords, the
Written
written statement your lordship should get at page 89, my lords.
Yes.
Please come to my lords. Para 5 at page 90. The written statement.
There is no para as denial.
Written statement. my lords.
Written
Para-
statement.
Para 90. I mean, sorry, running page 90. The written statement starts from running page 89
Hmm.
at page 90, my lords.
Yes.
Para 5. Submitted averment made in para 7 of the plaintiff falls contention that 2 residential sites belonging to plaintiff site number 404-405 is false and imaginary, exists only on papers. Aforesaid residential sites do not fall within the limits and boundaries of land bearing survey number 34/1 of Nagavara village. Layout plan relied upon by the plaintiff approved by the BDA in favor of Wildly Cowell House Building
Contention that it is quite.
quashed. For that, in my plaint, I have set out, if your lordship sees, the BDA, because of that order of the Honorable Supreme Court, had withdrawn its approval order or the resolution. That order was questioned before this Honorable Court. One minute, let me complete.
Because there are incomplete documents in
Correct.
this thing. For that reason, I have all the documents since
Very
from
well.
the data
You can pass on.
acquisition and this thing.
You can pass on.
Please, please.
Plaint
Yes.
court.
Sorry.
Lords, that was challenged before this Honorable Court. The BDA itself filed a memo and the learned single judge, my lords, quashed that resolution of BDA which withdrew the resolution plan. That's a part of the record along with my plaint. The order copy of the High Court is produced. It is along with my plaint. And averment also is made.
But that order of the BDA is quashed
Yes,
again.
yes. That, my lords, I have produced that order copy. I can.
When is that? Can you please tell the date?
My lords, that I'll just submit that, my lords. I'll just submit the date, my lords, and then show your lordships that.
What did they say about that sale deed executed in favor of Cariappa?
The court does not give a finding on that aspect.
Not the court, while filing the written statement, they have to advert to
Good.
that.
Can I just pass on the order is, my lords, 25/9/2014. This is a part of the plaint. That was a batch of petitions. That's a resolution which my learned friend is relying upon, which was set aside. In fact, BDA conceded to that fact.
After that, when was approval granted to you?
No, no, approval had been granted, my lords. The layout approval, my lords, as I submitted, the layout approval was in 2002 itself,
No.
2003.
If you look at 6.1, what it says is, the resolution dated 6/5/2012 bearing so and so.
That is withdrawing the earlier resolution.
Or set aside
Yes,
with liberty to the BDA to reconsider the matter afresh on merits in accordance with law
Yes.
after giving an opportunity of.
yes. After that, they have dropped it. They have not taken a penny.
No, no.
That is-
After that also, they have taken action, my lords. They have, after the legal opinion obtained.
No,
That's
no.
why, that's
I
why.
really, my lords, I
Because
think
incomplete documents, for that reason, I have every documents with
my
me. my lord.
learned friend either has to rely on the suit documents.
No, no.
If he is going on, please see his
Understand.
written statement.
Let him complete. You
Please, sorry.
can have your, you can make your submissions, and also that time we will look into all those papers.
Please, sorry.
So
Um,
from it, what it appears is that
Yes,
the
ma'am.
court had
Given
again
them
asked,
liberty.
again asked them to reconsider it.
Yes, they have not, because the approval of 12/9/2003 still stand. Lords, the layout plan was approved on 12/9/2003. In 6/5/2012, they cancelled that resolution. That cancellation order was set aside. Liberty was given to BDA to reconsider if they want to cancel. They have not taken any steps. Today, the layout plan is there, Kata is there, BBMP is issued sanction plans to everyone. It's a, lords, in a residential layout.
According to you, now that whatever is approval stands good. till
It is
now.
still standing. The BBMP has issued Kata, sanction plan in favor of others. Now, this is the position, my lord, so far as, and in fact, Supreme Court also directed, my lords, the society to file a compliance report in that judgment. Society filed a compliance report showing, my lords, which lands were part of 52/4 and which were also, my lords, purchased by Karyappa and assigned to the society. The Supreme Court closed that matter at that, taking the compliance
So
report.
you sought injunction not to interfere.
Not to interfere. And the very same defendants, my lords, in adjacent sites, they have suffered injunction orders because they claim 1 acre and 8 guntas.
That is Justice Shyam Prasad's order.
Yes, that is Justice Shyam Prasad. And there is one more order in another suit.
What is the name of the defendant? Let us see from.
My lords, please come. In that suit, my lords, initially there was only one defendant, page 136. The lordships would get Muniratnama, who is the first defendant herein, in this very same defendant.
Hmm.
You are not participant.
1 nimsh. I think my learned friend can wait. I will submit.
You please be seated.
Because
Court
my-
will hear you.
No.
All that you please note down and everything you can
As
submit.
she asked regarding who are the defendants in that MFA, but we were not parties in that
You
MFA.
know, please be seated.
They were not parties. Very well, my lords.
Yeah.
The first defendant was a party.
In this suit, Muniratnama is the first defendant.
The first
In
defendant.
that also,
They were
Muniratnama is the
first
defendant.
defendant. Now, my lord, please see the review petition which I produced to your lordships.
Hmm.
That review was filed
By Jayanti and Murli.
Jayanti and Murli, who are the second and third defendants,
See.
whom my learned friend represents. Seeking review of what your lordships would get, please come to page 2.
Yes.
Review petitioners have filed this petition for review of order dated 23/4/2018 in MFA number 2433 of 2018. That same MFA
Then what is the order finally?
dismissed by giving a categorical finding on all these issues.
Therefore, the question of de jure position.
Now, this order was questioned by them before the Honorable Supreme Court. First, they went to the Honorable Supreme Court, my lords. Took leave, came, filed review. Review was dismissed. Then, my lords, they went to the Honorable Supreme Court challenging the review order.
Take that. Do you have all these copies? You know
It's
what
all,
you know?
they are
No,
parties.
everything, my lords, I will submit.
The earlier Supreme Court order also I can place, my lords.
Sister,
Yes, this was the earlier order where they sought liberty to file review.
take that. So now the whole dispute is in respect of that 1 acre and odd, a sale deed that is executed in favor of Karyappa.
Karyappa.
Either this property or the one which is part of where Justice Shyam Prasad has passed an order, all that is arises out of that 1 acre and odd
Yes.
belonging to so and so.
Yes. my lords. And apart from this order, my lords, now please come to another order which is where an injunction has been granted against them, which we have produced, my lords. please come to page 166. At 167, another order is there, my lords. 166, your lordships would get the cause title. I just want to. In the civil code, in OS number, my lords, 9344 of 2018, please see the defendants Muniratnama, Jayanti and Murli, your lordship gets on top.
Yes.
And the injunction order, your lordship should get from page 167. This is in respect of site number 418.
So in respect of this property, the injunction is granted by the very same court.
Very same code. Lords, all these suits injunction.
Let's see what is the reasoning given in.
Yes, my lords. Please come to the schedule. Impugned order starts from 26 onwards, which we have placed all this. It starts from 26 onwards. Contentions are recorded.
Come to the reasoning part.
Lords, yes. Lords, 31, page 40 onwards.
Yes.
According to the plaintiff, state government had lordships, may I read? State government had initiated acquisition proceedings in year 1984 to acquire land in favor of Wildly Kaval House Building Cooperative Society Limited. Said proceedings initiated to acquire 428 acres of land in Devara Chikkanahalli, Kodi Chikkanahalli and other villages of Bangalore South Taluk. There was also a proceedings was initiated to acquire 164 acres of land in Nagavara village of Bengaluru. As per that, a final notification was issued on 21/2/86. The said acquisition was inclusive of property in survey number 34/1 of Nagavara village measuring 1 acre 8 guntas. The acquisition with regard to properties in Devara Chikkanahalli and so and so villages of Bangalore South Taluk were challenged by one Narayan Reddy before the Honorable High Court of Karnataka. The Honorable High Court was pleased to set aside such acquisition. The said judgment was confirmed by the Apex Court and such judgment was reported in 95-3 SCC 128. Property in survey number 34/1 was not a part of
I
such
think you
judgment.
can straight away come to para number 42.
40 minutes.
42.
Yes. I have perused the entire pleadings as well as documents relied by both the sides. As per pleadings of the plaintiff, suit properties are site properties situated in layout formed by Wildly Kaval House Building Cooperative Society. I have perused the registered sale deed dated 4/4/2009 executed by Wildly Kaval House Building Cooperative Society in favor of Sumati Hegde and Shruti Hegde. As per the recital of the said sale deed, Government Revenue Department, after completion of acquisition proceedings and award proceedings, has taken over the possession of 164 acres, 26 guntas of land and handed over the same on 23/11/92 by the land acquisition officer into the hands of Wildly Kaval House Building Cooperative Society. And in the said property, first phase of layout plan was finalized and sites were distributed to the members of the society. By virtue of such distribution, said Sumati Hegde and Shruti Hegde were allotted with sites 404 and 405 respectively, and sale deed was executed in their favor as per registered sale deeds dated 4/4/2009. But as per pleadings of plaintiff as detailed in the plaint, certain proceedings were held before the Honorable High Court of Karnataka and also before the Honorable Apex Court. And finality of such proceedings was reached by the order dated 24/4/2014 in Civil Appeal number 1930 of 2012. According to plaintiff, in the said order, Honorable Apex Court has received the compliance report filed by Wildly Kaval House Building Cooperative Society. Said compliance report is also produced by the plaintiff. Such compliance report was filed as per direction of the Honorable Supreme Court. In compliance report, there is a recital with regard to property in survey number 34/1 at serial number 12. In the said compliance report, no doubt it is forthcoming that the erstwhile owners of the property by name Venkatesh and Krishnappa have sold the property to an extent of 1 acre 8 guntas in favor of Karyappa, who was the nominee of Sri Shakti promoters and developers. And it's also stated in the compliance report that the said land was converted from agricultural to residential purpose as per the order of the Deputy Commissioner. Such compliance report was considered by the Honorable Apex Court in its order dated 24/4/2014. At para 12, it was observed by the Apex Court that the Apex Court is only taking such compliance report on record, which was filed by the respondent number 1 society, and liberty was granted to the appellants. Appellants are the landowners to agitate their grievance before the appropriate forum if they so desire. That means the contents of compliance report was not accepted.
No, and further also, that
Yes.
is, that I'm not able to understand.
In
Like,
fact, liberty was given to the appellant of the said case to agitate grievance before the proper forum. Hence, in my opinion,
that this is what it is, which I couldn't understand. What's the finding?
hence, in my opinion, mere containing regarding the sale in favor of Karyappa will not confirm title. There is a sale, confirmed. will not confirm title of Cariappa with regard to the property which he alleged as purchased by the land. Now, my lords, how the code gives this finding, you will get this done. Now, my lords, please see,
Yes.
they have filed now suits in 2020 after having suffered injunction against Cariappa and others. Learned counsel for defendant 2 and 3 have brought to the notice of this court that another suit in OS number 1144 of 2020 was filed by the defendants of this.
What the court says is the recital with regard to purchase by Cariappa was not mentioned in the main document. So that's why you are not entitled.
How, my lords, that can't be, and the court also holds, I may also bring to your lordship's notice, my lords, please come to para 44, last two lines from there, my lords. Title of Cariappa is to be proved after full-fledged trial. And the court says, my sale deed contains various survey numbers, so we do not know where your site is located. That exactly we have produced the layout plan. Layout plan shows each survey number with the sites comprised. My lords, the layout is formed over 98 acres. So the layout was approved with various survey numbers, including survey number 34. My lords,
Where is your sale?
my sale deed I have not produced, but it's in a part of the plaint. My lords, point out in that plaintiff chapter.
No, your sale deed must be containing this particular, what do you call the survey number?
Yes, all the survey number. The court says, including this, when Vayali Kaval societies,
Unless and until it contains. in which
34/1 is mentioned, including other survey numbers, in which the layout was formed.
If that is the case, what will happen is, initially it was 160 acres,
No, layout is for 98 acres only.
whatever. In between, something was dropped.
Yes, yes.
But in the
Yes.
respect of some lands we were continuing.
Yes.
Now, as far as this 34/1 is concerned, you are relying upon the sale deed. Because acquisition was, some of it is acquired, some of it is
Yes,
not
my lord,
acquired.
absolutely.
So, your land is in 34/1 or somewhere else is, it's a question.
That, my lords, that's what we have pointed out. 34/1 in my sale deed is mentioned along with others.
Yeah, but as far as these people are concerned, they are only concerned with 34/1.
Yes, 34/1, which was sold by Cariappa in favor of Cariappa in 2003. That sale deed is still in existence. They admit, now they have filed a suit seeking a declaration sale deeds executed in favor of Cariappa is null and void. So they admit that there is a sale deed. Now, so far, if your lordship sees the layout plan,
In respect of all the persons who have purchased a property in 34/1, they have filed the suits.
now they have filed a suit. They are, my lords, there are houses.
Fine.
My lords, one suit, if your lordship sees along with this,
Their suit is for declaration. Apart from that, all the other owners have filed the suits.
some, yes, as I pointed out, there are about 3
How many
suits.
plots are there in that 1 acre?
My lords?
How many plots must be?
My lord, should be about, my lords, I'm not too sure, about 40% will be, minimum 40% will be developed. There should be more than about, at least about 10 suits, 10 sites at least. Now, if they claim to be in possession of 1 acre, if your lordship summons anyone, the entire property is built up except a few stray sites. The modus operandi is wherever there is a vacancy.
Now it is, there is a construction in that.
All, my lords, even in the other suits which injunction is granted, there are structures.
The court says that you are not in possession of the property.
That
basing on-
I have not proved. If possession certificate, it's a vacant site. Now, what is the modus operandi?
No,
They will,
as far as these lands are concerned, they are vacant.
all the sites were vacant sites.
Hmm.
Now, my lords, at that point of time, wherever they find vacant sites, they will try to take that. What we have said, grant an injunction, protect. Now, my lords, they have suffered in 2 suits minimum, at least to our knowledge. And what my learned friend does not reveal, which we have not revealed because it was not a part of the plain. Their sale deeds, which they got from, my lord, the first defendant herself has filed a suit against them,
When did they
challenging the sale
purchase?
deeds
When did they purchase?
in 2017. Their sale deed, if your lordship sees, they refer only to the Supreme Court order. That's what is.
First defendant, that Muniratnama,
Gift deed is in 2011.
that is your vendors, Cariappa's vendors. How is she related to Cariappa's vendors?
My lords, I have set out, I'll just say, in the plaint I have set out, I'll just tell the relationship, my lords. In the plaint we have set out. I'll just read para 32 of the plaint, my lords, at page 68, running page 68.
Yes.
Under the subheading facts relating to gift deed being void in the plaint, my lords. It is submitted late Apogee was the original landowner of the land bearing survey number 34/1 of Nagavara village. He had three sons, Sri Krishnappa, Narayanappa and Muniappa. It is submitted that Srimati Venkatamma, defendant in OS number 6827 of 2013 and donor of gift deed dated 1/10/2011, is the wife of Krishnappa. It is submitted a perusal of the sale deed dated 20/05/2003 would clearly reveal that the three sons of late Apogee, including grandson Sri Ramesh, that is son of Krishnappa and father of defendant number 1, have sold the land bearing survey number 34/1 of Nagavara village for valuable consideration. The defendant number 1, Muniratnama, is none other than the daughter of Sri Ramesh, who is the signatory to the sale deed dated 20/05/2003. In spite of being aware that the property bearing 34/1 of Nagavara village had been sold.
She is their vendor.
Yes. And they purchase it through my lord, she executes a GPA. The GPA is none other than Jayanti's husband. So he executes sale deeds in his favor. Now, Muniratnama also has filed a suit against them. They also, as GPA holders, go on filing suits. But in their suit, there is no injunction operating against any of the vendors. But these two defendants have suffered at least through two injunctions insofar as adjacent sites itself are concerned. And these matters were adjudicated, my lords. Review petition also, this honorable court considered all these facts. Supreme Court has considered, civil court has considered. Now to say, my lords, there was an ex parte order granted, but the court now says I'll have to go through the entire trial to test title of Kariyappa.
Yes. Pass on those documents.
Please.
You gave them us those copies?
Yes,
Yes,
yes, I have,
yes.
sir.
And along with the plaint, we have produced the possession certificates also.
No, first, before going into all this, you have to clarify one thing.
Please.
Now, this, the whole extent, whatever you're claiming or that Muniratnama, that is 1 acre,
8 guntas.
8 guntas. Now, the order of Justice Samprasad is also pertaining to this 1 acre, 4 guntas. And in that also, the source of title and everything, all your, whatever your case is, one and the same.
Not, not. You will actually make kindly come to page number 136, madam.
136 of your paper.
That is the MFA preferred by one Mr. J. Prakash Madiraju.
No, 136 of this.
No, not 136 of main MFA. That is the
MFA paper.
Justice Champasa's order, my lords, in MFA 2433 of 2008.
Yes.
136. That is preferred by one Mr. J. Prakash Madiraju. That is the appeal preferred by that Mr. J. Prakash Madiraju, one of the site owner, my lords, by misrepresentation without made us as a party. Even prior to that, you will actually kindly come to the documents. Now I have produced, my lords. Now I have produced. You will actually kindly come to the page number 205, my lords. Page number 205.
Yes.
205, my lords. That is the sale deed executed by Muniratnama, including all the legal heirs of Muniratnama in favor of the defendant respondent number 2 and 3. In respect,
which year is that?
7/7/2017, my lords. That is actually, my lords, prior to filing of original suit related to that MFA, my lords. This is sale deed executed by
Definitely it will be after that because all of them have purchased it in 2003.
No, my lords. Actually, my lords, this sale deed is executed 7/7/2017 in favor of respondent number 2 and 3. After this, the suit in respect of that MFA has been filed by that person.
After that, you
without
came to
made
know.
us as a party in the OS suit. OS suit also he has not made us as a party and obtained the status quo order. And without ordering that status quo, he has preferred a miscellaneous post appeal before this honorable court. At that point of time, when he has preferred miscellaneous appeal also.
You will not have a better title than your vendor, is it not?
No. Actually, my lords, you will actually make it before that, my lord.
No, please understand. According to you, you were not made a party to that suit. Thereafter, when an order is passed in the MFA, you filed a review. Your review is dismissed.
Please, after that, my lords, that case, after that, now that case, now cross-examination has been concluded of PW1. Now, your lordship may kindly come to next documents. That is the deposition in respect of that suit. He has admitted that execution of the present sale deeds in favor of the respondent number 2 and 3 by the PW1, who is the none other than that Jayaprakash Mudiraju, my lords. Your lordship may kindly come to that. I have relevant portions I have marked in that. Your lordship may kindly come to page number 248, my lord.
Yes.
248.
Who is that?
My lords.
Who is the witness?
Witness, who is that MFA, that appellant in the MFA, my lords. Appellant in the MFA, my lords.
You are not able to understand. Who is the appellant in the MFA is not the concern.
Please.
Concern is
By
who is the
suppressing
defendant.
that, my respectful submission, my lords. After this MFA, my lords, we have filed, your lordship may kindly come to document number.
At least you agree that by the time you purchase the property in the year 2017, several transactions have taken place in respect of that property right from 2003.
No, my lord. No, no transactions, my lords. Your lordship may kindly come.
Kariyappa sale deed is when?
No, your lordship, Kariyappa himself is not having a title. He himself has filed a suit for declaration injunction. That's why, that is my submission before this honorable court. Your lordship may kindly come
Please
to
come
page
to
number.
that, not these. Please come to Kariyappa's case.
Your lordship may kindly come to page number 70, my lords.
70.
That is, my learned senior counsel is not submitted regarding that, my lord. Page number 70, my lords. Page number 70.
It's filed in the year 2018.
18, my lords. Against all this, against all the original owners who have executed sale deed in favor of Kariyappa, my lords. Against.
Dependent 1 and 2.
No, that, your lordship may kindly come to that page number 70, my lord. That is, Kariyappa has filed this suit against the respondent number 1 and 2, respondent number 2 and 3 herein, and against all the original owners, including society, my lord. Including society. Your lordship may kindly come to page number.
What is the suit for?
Suit for declaration injunction. He himself has sought declaratory relief against the respondent number 2 and 3 in respect of the sale deeds executed in favor of respondent number 2 and 3, my lords.
Please come to the relief that he sought.
Yes, please. Your lordship may kindly come to page number 91, my lords.
Yes.
Page number 91.
Yes.
Declare the sale deed standing in the name of first defendant dated 7/7/2017, registered as document numbers so and so, and also sale deed standing in the name of second defendant dated so and so 7/7/2017, which is registered document number MLS so and so. Senior sub registrar Malleshwaram, Bangalore is null and void, and consequently direct the concerned sub registrar to cancel the sale deed standing in the names of defendant number 1 and 2 in its books through the process code. Consequently, to declare the second plaintiff is
He
the
has not
owner.
sought for cancellation of a sale deed dated 12th May 20th May 2003. 20th May 2003 is a sale deed executed by him.
Executed by
this in favor of, that is in favor of.
Kariyappa by original landowners. That is the contention.
Hmm.
That is the contention. Your lordship may kindly come to.
Thereafter, the next sale deed is also on the same day.
My lords, here main person is Kariyappa, my lords. He is the played role in the present transactions. My lords, as far as these transactions taken place in the year 2003, as per that sale deed executed in favor of Kariyappa, no consideration has been passed, my lords. According to the title has been claiming by the appellant, my lords, during pendency of the suit filed by me against the predecessor entitled to the appellant, my lords, during the pendency of the suit, by suppression of that fact, the sale deeds came to be executed in the year 2023. My suit has been filed in the year 2020 for declaration injunction. Your lordship may kindly come to page number 27, my lords. Page number 27.
What do you say about the sale deeds of 2009?
Yes.
2009 sale deed of this plaintiff's vendor's vendor.
That's why, your lordship, that they were not having claim. They themselves have admitted.
So all of that have to be decided now?
Well,
you have the sale deed in the year 2018.
17.
17. There are some sale deeds before that in 2009 and 2003. All of the court has to decide all that. It's a public document.
Please, for that reason, my lords, they failed to prove the possession over the property.
You have not questioned those documents till now.
No, we have questioned that for that reason.
When you have filed the suit?
In 2020, my lords. 20, the present sale deeds came to be executed in favor of the plaintiff in the year 2023. Even they were parties to our suit. They were represented. Very same advocate is representing in the same case. For Kariyappa also, very same advocate is representing for Kariyappa.
After after they have purchased the property, you have implemented them to.
Please, my lords. Please. What happened, my lords? After the filing of MFA, after they obtained the order against us.
Suit is filed in which year?
Which suit, my lords? This.
That's a new suit.
Recently, 2024, 23, my lord.
After these, we
My lords, your lordship, I may, your lordship may kindly come to. One, before that. I
He
will
has
clarify.
filed 1 minute. He has filed a suit for declaration.
Yes, my lord.
And injunction.
Yes,
That he has made you a party respondent to the defendant to that suit.
my lords, please come to his suit. He is only made, please come to his suit, my
Page
lords,
number 6.
1-1,
Page number
along
6,
with
my lord.
his
Page number 6
compilation.
along with my today's.
Page number?
Page number 6, my lords.
Document number 1.
Document number 1, page number 6. That is the cast title. That Sumati Agde and Shruti Agde, defined number 20 and 21. They are the predecessor in title to the present plaintiff's sale deed, my lords.
Lords, he has made everyone, including Jai Prakash.
During this pendency of this, my lords, the present sale deed in favor of plaintiffs came to be executed.
Doesn't matter.
That is attracts under section 52 of the Transfer of Property Act, list pendency. By suppressing that fact, your lordship will kindly come to.
Lords, I
we have
don't
asked-
understand suppression. There is no injunction in
Actually,
his
my lord,
suit.
see, my respectful, even they themselves have admitted that your lordship.
Filed in the year 2020.
Yes,
But your
my lord.
vendors have sold the property in 2023.
23. There is no injunction.
After me filed suit against them, predecessor, they were not supposed to sell the property by knowing all these facts.
I don't know, my lords, if my learned friend says,
That reason you
is
are.
there an injunction granted
My
whether?
lords, your lordship may kindly come to reasoning given by the trial court in respect of that.
He sought for any injunction or any order restraining them from alienating the.
Please,
property.
my lords, we have sought that what happened, some other sale deeds came to be executed.
Was it granted? Was it granted by the court?
No, even till today, some of the parties have.
Have not been served.
Notices to some of the parties have not served in this, in that suit, my lords. In that OS 111.
No, even the Jayaprakash, who is the appellant in the other suit,
Please.
other appeal,
Please,
is also a party to this.
please, my lord.
Where is he? Where
Your
is
lordship
he?
may kindly come to. He is also party.
In spite of that, an order is all passed in his favor, all similar set of facts.
No,
He has
after
implemented-
MFA, we have filed this suit, my lords. MFA in the year 2018, my lords. See, what happened, my lords? Jaiprakash Madhiraju has filed a suit for declaration injunction before the trial court without made us as a party, only has made a Munratnama as a party.
What is the date of order MFA?
MFA is the order dated one.
You have produced the original order, my lord.
3rd April 2018.
23 April 2018, my lord. Even as on the date of filing of the original suit of Jaiprakash Madhiraju, we were purchased the property, my lord. He is admitted in the cross examination.
But what you have to understand is, while granting injunction, court has considered the case of your vendor, that is Muniratnama.
Munratnama. Title has
Whether
been
you
denoted.
are-
I have produced the documents. You will actually kindly come to documents.
Please understand the court's query, then you can answer.
Please.
Now, the whole, whatever Muniratnama is having, you have purchased the property, so she cannot confer better title than what she has on you. Is it not? First you answer to that at least.
No, what happened, my last Munrat?
Can your vendor can give you a better title than what she has? Can she give?
My last, as far as the sale deeds are concerned, you are, for that reason, I may see, my last.
You're complicating the whole issue.
No, no.
You have
my-
purchased the property from Muniratnama.
Not
Whatever,
only Munratnama, my last, entire family members who have executed sale
let's
deed.
say entire family members,
Please.
whatever the entire family members and Munratnama,
Please,
whatever the right they are having,
Please,
that they can only transfer to you,
please,
right?
please.
So earlier in 2018, before your purchase, Muniratnama was there before the court as a defendant. An order was
Not
passed.
earlier to us, my lords, after we purchased. After we purchased, for that reason, my lords, I have produced the documents because the Jaiprakash.
What you are saying is contrary to your submission is now to the, contrary to the earlier submissions. What you say initially, when a suit is filed, Muniratnama was a defendant to the suit. The plaintiff, the plaintiff therein has not made you as a parties to the suit, right?
As on that data, as on the date of filing, my lords, Munratnama was not having, she has transferred title in our favor. They were not supposed to made Munratnama as a party. They were supposed to made us as a party.
As
my
a
lord.
party.
If
You,
we,
yes, you as a party.
please, my lord.
The court has considered Muniratnama's title or not? incidentally, while granting injunction.
Suppressed our sale deeds, my lords, for that reason, my lord, before that, your lordship may kindly come to, their plaint, your lordship. Their plaint before the trial court in this present suit.
What you have to understand is for granting injunction, the reasoning of the court was basing on Munratnama's title. And what is the title of the plaintiff? And what is the title of Munratnama?
My lords, even knowingly, my lords, the plaintiffs have purchased the property from predecessor title. They were suffering title from before this.
When did Jayaprakash purchase?
Jayaprakash Madhiraju purchased prior to this, my lord, 2009. 2007 sale date. But this person 2023, during pendency of all these litigations, my lord, that is my, and also your lordship may kindly come to awareness of the plaintiff.
Yes.
Awareness of the plaintiff. They themselves have admitted regarding acquisition proceedings. Your lordship may kindly come to page number.
When pending proceedings, how can your vendor sell the property?
Lord, there is no injunction. We do not even know whether those people were served. My learned friend said, Lord, it is not only list pendants. Yes, I will take that risk. But that does not mean that he can do whatever. If your lordship may kindly take the review petition for a moment. 1 minute. If your lordship takes the review petition order.
All the approval granted
I
by
don't know, my
the
lord.
VDA have been cancelled, my lords. That is I have produced. Government
If
of
my
Karnataka
learned
has
friend
cancelled,
has-
withdrawn all the approved.
All this contention.
Even my lords.
1 minute, I'll listen.
Please
Let
take
me
the
listen.
review petition order, my lords. Please see, it is not only injunction, after injunction, what all he has suffered, which is called out in the review petition order. Please come to para 8, page 11, my lords, of the review I'm referring to.
Yes.
My lords, please come, last bottom 5 lines, my lords. On a subsequent application, your lordship gets it, my lords. Filed by the first respondent in OS number 5967 of 2017, review petitioners have been restrained from alienating the subject properties. Review petitioners have also filed an application IA6 in OS 5916 of 67 of 2017 for injunction against the first respondent from proceeding with the construction, and this application is pending. Then please see, Learned Senior Counsel submits writ petition filed by the review petitioners in 22-911 of 2019, calling in question the order dated 1/4/2019 by Civil Court in OS 5967 of 2017, directing police to give protection, has been dismissed on 15/7/2019. Further, writ petition filed by the review petitioners for cancellation of the sanctioned plan building license issued in favor of first respondent in WP number so and so are dismissed as withdrawn on 26/7/2019. It's only after these proceedings review petitioners have filed their special leave petition before the Honorable Supreme Court. Then, my lords, they have suffered police protection orders also. Now to say it was only by have suppressed all these things, it is not a suppression. That is there who have suppressing things. And he says all this. Does he even reveal, my lords, he has produced some paper book of about 300 pages. Does he even reveal that a suit has been filed against him by Muniratnama? In 300 pages?
That is in respect.
Ah,
That is in
please.
respect of different survey number 24.
Lords, 34/1 only.
Where is it?
Lords, he is aware, we are aware, we have
We
put
were
it.
not aware, for that reason, we were, let him to produce that.
My learned friend, he knows.
Please
lord,
tell
even
please tell the court from these papers that the permissions that were granted in favor of
Please,
the
madam, please, for that.
society were cancelled.
Yes, madam. Your
Yes,
lordship may kindly
madam.
come to. Today's I have submitted documents, your lordship may kindly come to. Page number 99. That is only before that I have. 99. Order,
99
Supreme
is a
Court,
draft.
Supreme Court's order in that respect of that acquisition proceedings. Before coming to that, I may be permitted to read relevant portion of that. How the society has played fraud before these to the members. You will also may kindly come, may permitted to read a relevant portion. Last,
All those
mark,
are not relevant, Mr. Counsel.
please, man. What happened, my lords? The Karyappa is not, he is only, he is the main, he is playing fraud before the
No,
court.
let him play fraud, get that sale deed, whatever is executed in his favor to be cancelled, file a suit for that. No, the
Yeah.
court will not go.
Please.
Placing on some material, you please tell the court
According
that.
to them, how they are claiming the title that my lords, Karyappa has executed, Karyappa executes sale in his favor, and He has executed GPA, that is your lordship may kindly come to that, my lords. Where is the GPA they have produced?
You were submitting that, all the permissions were cancelled by BDA, that you
Please,
please show to
your
the
lordship may
court.
kindly, your lordship may kindly come to. Page number 162, my lords. That
When is this order?
That is in Kannada, my lords.
When is this order? Please
That is
tell
in,
the date of
in the
order.
year 2005-6, my lords.
No.
It is
Anita,
in Kannada.
give that. No, by this, it is set aside. Now a writ petition is filed.
After that, my lords, after
after
filling
that,
up that
petition
writ
is filed.
petition, again they have mentioning that writ petition number and they have cancelled again, my lords.
Where is that?
That is there, my lord. Your lordship may kindly come to next, my lord. Page number 167, my lord.
This is
167,
passed when? Please tell the date of the order.
that
It is on 26/8/2014. When
Please.
is the order of the,
High
order
Court.
of this court?
your lordship, that is column number 6, my lords. In that column number 6, Manya Uchanaya, the WP number 22219,
You are referring to
30
that
of
order. which
2014, that
page?
writ petition, I think.
Mr.
Yeah,
Senior
that
Counsel,
writ petition only.
My lords,
that,
Lords.
you're referring to that writ petition.
yes, my lords,
The
I
page
just,
number?
I have given that, it's,
By considering that judgment only, again they have withdrawn the approved layout plan.
lords, please come to, that's the order, my lords, 25/9/2014 was the High Court order. In 27/7/25 of 2013.
That is connected matters. There are some,
25/9.
there are some connected matters.
1 minute, when is the order of the High Court?
My lords, order of the High Court is 25th of September 2019.
Please look at all the documents and come back.
And it's a
with-
part of the plaint.
Please,
It's a part of the plaint.
Not looking at it.
Please, I kindly have next week, because today only I have prepared all these documents. Served on the senior counsel. Kindly have next, so any date may be given, my lords, I will.
45 minutes of the court
No,
time is
actually, my
gone.
lords, what happened, the lengthy this thing, my lords. Even I have prepared everything and I have highlighted this important
You should,
things
there is
also.
nothing important that we are not understanding.
No, actually, my lords, they,
You have the earlier orders there, they.
oh, only they are claiming that,
entitled for
that
effective-
MFA order, that is not at all related to this, my lords.
There's one more suit in
It is
that.
not at all to related to this, my lords. Only they are claiming MFA.
Then just like that, you are making statements saying that, that permission is cancelled without any basis.
No, that is cancelled, my lords. Government order is there, that's why I have.
That's not, that is
That's true.
prior to the
No,
order of
not
the
prior to
court.
that. I will get that judgment and with translated copy I will submit in the
I'll give
next,
you only 10 minutes on the next date of hearing.
please.
Post, place this also. On, post this matter on 20th.
That's 24th or something, because I'm not in the country from 15th to 21st.
Post on 30th.
Please.
Much over.
Cell number 19. Mohan PS. Cell number 19.
No representation for the appellant. Post this matter on 26th.
Please.
Number 20.
Just for the appellant, madam, so pass over maybe.
Capitalized.
Passover.
May I request on Tuesday, my lord. My lord, there is urgency, my lord, will be passed over, Tuesday will be long.
What is the difficulty for a Passover?
The senior is held up elsewhere, he is also finding it difficult to come here, therefore, I'm saying it's
Maybe
not
the-
inconvenient on
My lords,
Tuesday.
there is urgency now, so they have in their favor. My lords, if the this restaurant and bar is
Interim order
open.
has been rejected 2 months back, my lord. 2 months back, they
My lord.
filed
Post
the
this
petition.
matter, the request,
My lords may be taken up tomorrow.
post this matter on 20th.
My lords, maybe taken up tomorrow, my lords, there's urgency. 20th will be a very long date, my
Tomorrow,
lords.
tomorrow
Maybe
not
taken up
possible.
Monday, my lords. My lords, Tuesday. My lords, Tuesday.
Cell number 21.
Yes, 20th.
Cell number 22.
I'll pay for the petition.
For the respondent.
No saving.
For the respondents.
Please.
22.
Where?
Well, it's,
Akash Kumar.
well, there's
Please,
an
ma'am.
order in this case, my lords, pay the interim maintenance of 20,000 rupees. And that was vacated, in spite of which, they're not paying any of the maintenance to the child, my lord. They're only paying 15,000 per month, my lords.
Not
the,
This, RPSC of 2020, no urgency now. Post this matter on 15th of October.
My lord, I'll argue the matter.
My lord, the
We'll
court
hear
below.
it later point of it. No. Yes. Next.
Number 23.
I appeal for the
23, I
respondent.
appear for the petitioner, my lord.
Appeal for the respondent.
Petitioner.
Yes, 23 pass over. Next 24.
Number
24 also pass over.
My lord, we are here, 24.
Pass over.
I'll just take 5 to 10 minutes. I'm for the respondent daughters. That's why, because I.
Yes.
24.
Let's, father's revision petition. The respondents are the daughters. No dispute regarding relationship,
How much is the amount granted?
6,000 each. 6,000 each.
Hmm.
Total 12,000 awarded by the trial court.
Hmm.
Alas, the respondent's mother has got a divorce, a decree of divorce on 25/9/2014. Since from 2014, the respondents are within the custody of the mother.
Okay.
So admittedly, the first respondent is major in age. The application, the miscellaneous petition filed under section 125 CRPC. In the entire petition, there is no disability or not maintain herself. They are not mentioned or drafted any disability.
If she is not disabled, she is not entitled for maintenance.
Under 125, she is not entered. Because she is aged about 20 years at the time of filing the petition. Now she is 24.
There is a judgment of the apex court where the apex court said a major unmarried daughter, when an application is filed under 125 CRPC, without relegating to her to file a petition under the guardianship, under the Hindu Maintenance
20
and Adoption
20
Act.
class 3 of Adoption and Maintenance Act. That
Instead
is
of
separate
that,
proceeding.
the courts can grant maintenance here. That is the judgment. Mr. Counsel, please get the judgment.
My lord, sir, I have that judgment. For that, in the year 2014, the respondents have filed a partition suit against this petitioner, and they have got a partition decree in the 2023. By suppressing that fact, they have filed a 125 proceedings after the passing the judgment in the partition suit.
What is that?
There is in the partition suit also, they pleaded that the respondent has neglected, the petitioner has neglected. That's a para number 4 of the judgment. The second defendant has completely deserted and neglected to maintain the plaintiff and their mother Rupa. The second defendant.
What is the property they've got?
1/3 share.
What is the property?
Joint family property. Property, my learned friend claiming that he is having a 1 acre Akonet land.
I'm
But
sorry,
it
I am
is-
not claiming anything. I was not the counsel over there, whatever the. Either.
Halala.
He is mentioning.
He is,
I do not know anything
my
about
lords,
it.
he
I am the
is-
counsel in this petition.
Today I received the objection, statement of objection.
It's not an objection. Objection I filed on the very first day itself to dismiss this RPFC. I have just stated in 5 to 6 paras, but why it is to
No,
be
when he is
rejected. That's
referring
it.
to you, he is not referring to you in person. That is anybody who is a counsel of your client.
That's true, because.
So don't have to take it
Yes,
personally.
that's.
So very same scheduled property is mentioned in partition suit. Whether after obtaining the partition decree, the children are.
That property fetch them any income.
100%.
What is that property? What is
That
it?
is
When is this order passed? It is on 30th January 2023. And when is this
my lords,
order passed?
after obtaining this decree, they have filed a 125 proceedings for the honorable family court.
Oh, this RPFC, which is before the court, is in the year 2023.
Correct.
When is the order?
My humble submission is, at the time of filing the criminal miscellaneous before family court, they have got the this judgment, and FDP proceedings also still pending before the Tumkur court.
When is the order passed in criminal miscellaneous?
Criminal miscellaneous order.
125 proceedings and partition proceedings are entirely different. They have no connection with
Correct,
other.
but they are suppressing the partition decree. They are suppressing the total decree of the partition.
It is passed on 30th January 2023.
Correct.
When is that RPFC? When that miscellaneous order?
Miscellaneous order 7th March 2023.
7th March?
2023.
So where is the suppression of this?
In the entire proceedings, they are not mentioned. I have,
What is the bearing of that to this?
the petitioner is doing coolie work. He is having his wife, his aged parents, and also a daughter from the second wife.
That you tell the court, your argument should be that he is not in a position to pay them. Not all these things.
My
First and
legal
foremost-
point is whether after obtaining the partition, they are entitled for maintenance from the father. Is my point.
125 doesn't say so, that if a partition is
And
obtained.
moreover, after the aged major in the age, they can't claim the maintenance.
I have filed a memo, my lords, because it's income, my lords. I got the instruction that
Get that judgment on this matter after a week. Yes, next.
statement.
That's in the
on that.
20th
Because
Friday.
one thing is, my lords.
20th Friday.
20th.
One submission I have, my lord.
Yes,
The daughter, my lords, there are two daughters.
yes.
One is studying in MBA, my lords. She has taken a loan of 2 lakhs rupees. I have enclosed that documents, my lords. And even prior to that also, the Honorable Family Court granted the educational expense along with the maintenance, my lords. That has not been checked. All those things are there. And the person is having Arikanut plantation by which he is getting 5 lakhs rupees per annum, my lords. They are staying in the same village, my lords. Even the divorced, respondents and his divorced mother
We'll hear
and a
this.
petition, they are all staying in the same village. They
We'll
know
hear it
about
on
the
some other
income.
day. Yes,
He
next.
is
Next matter.
Chair number 25.
That's 20th is
This
not
file-
possible. 20th.
Matter on 30th.
This memo I filed, my lord, I copied.
You should not file memo like this. It should be, memo should be filed by way of a proper manner. Yes, 30th.
That much.
Chair number 25.
Appear for the appellant.
Checker KM.
Yes.
Enhancement of compensation, madam, I am restricting prayer only with respect to the plants and trees.
On the last occasion. you
Last
wanted some
occasion, I made a
judgment.
submission, yes.
Where is the judgment?
Put in.
What was the contention that you are advancing on the last occasion?
Last
Check
occasion. Last occasion with regard to land values also 3 times it has to be multiply when for one each year. That was the argument. Now I have given up that argument. Now I am restricted only in respect of, since this is already given a sufficient compensation with regard to lands. I am restricted my prayer only with regard to plants and trees. There are 91 coconut plants, 1,880 arachidid plants, 21 mango trees. And these are the evidence given before the court below. This has not been denied or disputed by the other side. The learned judge was entertained the 18 reference has not considered the coconut plants and other plants which are existed in the.
Come to the order. Let's see
Please.
what the judge's
Yes.
discussion on that.
Yes. He has not even whispered with regard. Your lordship may
Where
kindly-
from the court can find about these plans and other things?
Milord,
Where from the court can find?
court can find from one is exhibit P9
Give that. Exhibit P9.
and other admitted documents I have produced along with appeal.
What is exhibit P9?
Exhibit RTC, record of right.
No, before the court, you must have reduced evidence.
It has produced.
Hmm.
RTC was produced, yes, exhibit P9.
Sale deeds, RTC,
Sale deeds are with respect to the properties which were sold earlier to the land, earlier to the acquisition. And it was taken for consideration for awarding the compensation with respect to land.
oh,
Exhibit,
I'm looking at that RTC, where will you get that?
exhibit P9, your lordship may kindly see.
Hmm.
Exhibit 29, it is in Kannada. It's a Bagaito. Bagaito means garden land. Tengu, coconut. It has been
So
mentioned.
number and all.
But number is not mentioned in the RTC.
And where from we have to get it?
Your lordship, may so far as number concerned, there is no record produced.
Then without that.
Oral evidence is there that has not been disputed by the respondent. He has given an evidence before the court. And Bagaita itself defines that it's a garden land.
That is true, but how many are there is a question.
That is the only oral evidence is there. But even in the documents which are produced along with the appeal memo, it is an admitted document produced by the land acquisition officer. He also says that it's a garden land. But he has also not mentioned the number of trees and coconut plants which are existed.
During the course of land acquisition, all those things have to be mentioned. There, it must have been there in
Yes.
the records. No,
There is
if
no
there are
evidence.
standing, any trees or there, any other things, because they also fetch compensation, it has to be recorded.
Yes, yes.
So in some proceedings, it must have been there.
There is no.
For the court, you should have sought for all that.
Your lordship, may kindly see, the learned judges not even whispered with regard to the nature of the land. The compensation uniformly,
By looking at this RTC, let's assume that it is a garden land.
it's a garden land, coconut plants are.
Then what
Only with
comes is-
respect to the number of plants, there is no material on record. My submission before your lordship, categorically, the appellant was examined before the civil court, and he has stated, but that was not disputed by the respondents. That is the only evidence available.
They have not raised any objection regarding these trees, my lord. Your lordship may kindly see page number 37, ma'am. Award of SLO.
37.
37, ma'am. About mango tree, there is no mention of trees. Mango is there, it has covered only 6 square feet, my lord. Then coconut tree is there, it is covered only 260 feet only. And another areca nut is there, my lord, it is only 0.41 square meter of land is covered. They have not challenged this before the reference court as well, man. They have not mentioned trees. There is no evidence regarding the number of trees are there. They have not given that valuation, then yield. There is no evidence regarding these plants, man. Before SLO or before reference court, they have not brought to notice about these things.
You have compensation for the land, not for the trees.
Your application before the reference court, your petition seeking
Yes, yes, ma'am.
enhancement, where is it? You have a copy of it? Let's see, did you ask for that?
Friend's petition is not with me, ma'am. I'll produce.
Must be there in the record also.
You may kindly see page 37, there is a reference with regard to the coconut plant that is in the award and mango and arachid. They given the extent of the land where the coconut plants are situated, but not given the numbers.
When when it is referred, when the reference is made, you will claim what you want.
Yes,
What
yes.
are, but nothing is there, or some documents are there in Kannada. If you just want anything you can find, please look at this.
Please.
Let them have a look at it.
My lord, sir.
Possible?
Next Wednesday or Thursday.
Friday. 20th, Friday. In the meantime, you can have a look.
Please,
at
please.
it. Yes.
My lord, serial number 20 and 20, my lords. My lords are given date on 28. My lord, serial is not available on 28, my lords. Matter may be taken up on earlier on 17th or 18th or 19th, my lords.
19th.
Please.
Give the number, take that some number. in-
Serial number 2021, my lords.
My lord, 22 also. My lord, 22 also, my lord, there is some personal inconvenience.
Hmm?
22 also, my lord, there is some personal inconvenience.
No, every matter, no one time adjournment, again inconvenience.
Alla, my sister's marriage is there. 15th I will not be available.
That you could have told the court, 24.
No, 15th, my lord, 15th. 22. Serial number 22.
Because it's difficult for them also again to pick up the bundles and all, 15.
15th, my sister's marriage, my lord. After 15th.
Case, which is the
22,
item?
my lord, 22. 22.
When do you want?
After 15th, my lord.
After?
After 15th.
Pose this matter on 14th of October.
Alla, 15th is my sister's marriage. After.
You mean to say October 15th is a marriage?
Please, my lord.
Propose that on 24th of October. Yes.
My lord, I apologize, my lord, serial number 2021 may be
Yes,
taken.
I've already told.
I apologize.
Serial number 30, my lord.
No mentionings now. Yuta.
Lords. Serial number 18, my lords, senior had given a copy of trial court records for reference. If I may just take it back and I can make a copy and give that, my lord. The reference ಬೇಕಂದ್ರೆ ಇನ್ನೊಂದು ಅದೇ ಹೊಲ್ಕೊಡ್ತೀನಿ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
There is a direction and not circulars are.
ಇದೆಯಲ್ಲ?
ಅಲ್ಲ ನಾನು ಅದನ್ನೇ ನೀವು ಅದು ವಾಪಸ್ ಕೊಟ್ರೆ ನಾನು ಸ್ಟಿಚ್ ಮಾಡ್ಬಿಟ್ಟು ತಂದ್ಕೊಡ್ತೀನಿ.
ಅದೇ ಯಾವ್ದನ್ನ?
ಇದು ಅದು ಕಂಪೇರ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲ ಅದು ಇದು ಒಂದ್ಸತಿ ಕಂಪೇರ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಲೈಕ್ ಪೇಪರ್ಸ್ ಆ ಕಡೆ ಈ ಕಡೆ ಆಗ್ಬಾರ್ದು ಅಷ್ಟೇ.
230.
Matters at 230, list number 3, serial number 1. List number 3, serial number 1, Mari Gowda.
Yes. A week's time default clause. 3, 2.
That is delete from caption of dismissal, ma'am.
Oh, these are all in dismissal. Oh.
Delete from cap.
No. Then don't give time.
Yes, sir.
I didn't see that. All this dismissal list, call at the end of the list.
Okay.
Around 4:30, you call this.
Yes.
There's so many matters in dismissal. Hmm. From
Number 29.
nine,
Serial number 29 for orders. SR Hegde Utlamane, list 3, serial number 28, 29.
Hearing for the appellant. Lords, in the last date of hearing, it was fixed for to take the paper publication. And submission was made before the court that they were in view of the earlier order for paper publication. Appellant could not come before to the office and take the draft for the paper publication. And your lordship wanted to hear on the merits, my lords. Today it was posted. I request your lordship to take up on 18th, my lords. Will senior has to argue. I am not on the record in this appeal, my lords. Kindly take up on 18th for main merits admission. We'll argue on the merits, my lords.
postponed 26.
26.
Yes, at the request of counsel for the appellant. Yes.
Cell number 30. Keshadri NS. Along with counsel.
Office objections regard to translation copy of partition deed minutes.
What is that? Let's see.
Partition deed was in Kannada minutes.
46.
For limited purpose, it was
What is
shown,
this document?
it was a partition deed between defendants and other members minutes.
Office objection, with regard to translation of, filing a translated copy of, is overruled. Pose this matter for admission on,
I request for the copy.
on 23rd.
Number 31.
Then counsel shall serve the counsel for the appellant shall serve a copy of the appeal memo on the counsel for the respondent. Serve it today. Please. Yeah.
31. Mesh Kumar.
So far as notice to respondent number 1 to 9, 11 and 12 are concerned. But they were placed ex parte and the appellant is not seeking any relief against them.
Take that memo. The memo is filed stating that notice, seeking dispensation of notice to R1 to R9 and R11
Also,
and R11 and R12. They
10,
submitted that they were set
10,
ex parte
13 and
before
18
the-
also.
Huh?
10, 13, 18.
No, latest you have filed.
Now I am filing and one more memo,
And
which I have
also-
not included in that one.
And
Yeah, that-
also, the respondent number 10, 13 and 18. It is submitted that they are not claiming any relief against those respondents. Their notice to mention all the numbers. So and so is dispensed with at the risk of appellant. Then,
Lord,
so
because
in that case, R10, R13, R18, no notice. So process is not required.
not required.
Oh.
Already the caveator is served.
Poses matter for admission on 23rd.
Lord, before that, if it is possible. 17,
20th.
please,
Yes.
much.
Cell number 32. Prasanna Kumar.
The appellant, my lord. Office has raised objection as to the maintainability of the appeal. In view of the plaintiff suit of the property, suit property has been valued at 10 lakhs rupees. It is respectfully submitted that initially the suit was valued at 6 lakhs rupees. Further, on an application filed by the defendant under 7 Rule 11, stating that the suit is undervalued, an order has been passed accepting the SR value provided by the defendant number 1, treating that suit is valued more than 20 lakhs rupees. So as such, I have further paid the court fee valuing at 20 lakhs rupees, and the court has accepted my valuation. Now, to substantiate that, I have filed a order passed on that 7-11 application at the end of the appeal. Page number 9 of the order may be taken.
What is the office objection?
Office objection is whether MA lies or MFA.
Below 10 lakhs.
Below 10, since the suit being
Where is that page number?
at the last, my lord, separate, it has not been paginated, unfortunately. We have filed that order passed on 7-11, page number 9, internal page 9 of that interim, the order. During the pendency of the proceedings, the plaintiff made fresh valuation of the suit claim as per sub-register value and paid additional court fee of
In order
36.
to find that.
After Wakalat, we have annexed that order. Sorry, my lord, it's not been paginated. That is order dated 13/3/2024. Page 9 of that order may be seen. May I read, Miller? During the pendency of the proceedings, the plaintiff made fresh valuation of the suit claim as per the sub-register SR value and paid additional court fee of 36,000 apart from the initial court fee that was filed by him at the time of filing of the suit. The counsel for the defendant number 1 has not filed objection to that fresh valuation slip. As per the SR value that is produced by
What is
defendant
that
number.
valuation slip?
SR value, the first valuation slip is produced at page number 40 of that appeal, my lord.
That is valued at?
Valued at 6 lakhs rupees, which is valued at 6 lakhs rupees, and court fee paid is 19,915.
Then where
The
is the
fresh
petition?
valuation slip, which is referred to in that order, my lord, is not on record, but we have paid the court fee accordingly. I am of the opinion that the valuation made and the court fee paid appears to be proper. So the court has accepted.
The paid.
Lord?
Court says that the court fee paid is 36,000.
Yes, ma'am.
Earlier, how much you have paid?
Earlier 19,000 I had paid
Earlier, what was the valuation?
at 6 lakhs rupees,
Now, what is the present valuation?
20 lakhs rupees.
So when 6 lakhs, you paid 19,000, at 20 lakhs, it is 36,000.
36,000 I have paid.
Please come. The office has raised an objection with regard to maintainability of this appeal as a valuation of the suitors. The valuation suit itself is 9 lakhs. Land counsel for the petitioner, land counsel for the appellant submits that initially it was valued at 9 lakhs. and
6
they have paid
lakhs.
Huh?
6 lakhs.
They valued at 6 lakhs and paid the court fees of
19,000,
19,000.
19,915.
19,000. And later, during the pendency of the proceedings, a fresh valuation is made as per the sub-registrar's value and paid an additional court fee of 36,000. And now as per what is the fresh valuation?
Fresh valuation is valued at 20 lakhs 40,000.
They valued it at 20 lakhs 40,000.
And
The appeal lies to this court. The office objections are sustained. If the other objections are
that has
complied
been
with,
complied. My lord.
post the matter for admission. Yes, next.
Cell number 33,
Obliged.
Parashurama Rital, Terkihal.
Hearing in favor of petitioner, my lord. Senior is out of station.
Oh.
Matter may be listed on this. Yeah, after paper publication has been done, madam, as per the instructions of the court, paper publication is.
It's coming up for memo for acceptance of paper publication. As for the order passed for the spot, the appellant had taken out notice to the respondents by way of paper publication. I think the same is placed before the court for acceptance. The PNS, no notice, don't write that, no, don't write. What are the proceedings? Docket orders. As per the order dated 23/7/2024. Appellant was, appellant had taken out paper publication in Kannada daily newspaper. And, there is the same for acceptance before the court. The same is accepted. Yes. Yes, post for it, petition. Yes, next.
34. Till number 34. It says to that.
Needfulness has been done, your lordship, today.
Yes,
TI
sir.
and TI is pending, your lordship. Kindly short date may be given, your lordship, some urgency in the matter, your lordship.
What is pending?
Stay and TI, your lordship. Temporary injunction.
It is submitted that the needful is done. Poses matter for admission. On 19. Yes, next.
Much obliged.
Till number 35.
For the appellate, for the petitioner, in matter, we have paid the amount which was directed to be paid till 18/12/2023, my lord. The balance amount we wanted to pay, but they have not accepted it there. This is my oral instructions, my lord. And memo of calculation I am required to file, my lord. If lordship gives me time, I'll file the memo of the calculation. As also, whatever due is there, we'll pay it on the next date of hearing, my lord.
My lords, may I please? 18/12/2023, my lords may see the order. They require 9 months to file memo of calculations. My lords, I have prepared my memo of
The
calculation.
matter has been transferred to me.
My lords, please.
See the file and look at it.
We need
Serve a copy, my learned friend. My lords, the entire arrear still date, apart from what they've paid, is about 14 lakhs, my lords. And I have detailed out as to what they have paid and what they have not paid.
Very good.
But it's on-
I'll do one thing, my lord. I'll put it to my client and get it because we have paid one on 20th of September 2022. We have paid, we have filed a memo also before this honorable court. 5,56,500 was paid. 1,89,000 was paid on 18/12/23. It's now from January, whatever is due, that I am required to pay as maintenance. All other matters which are pending.
What is the monthly maintenance?
But
is
7,000 rupees or so.
Then he says 14 lakhs. From January, the arrears won't be that much.
But that is what they are claiming, my lord, 14 lakhs. I do not know. That
Dates
is why
back.
I'll have to put it to
Then
my
you should have
client.
filed, if you're disputing it, you should
Because
have filed
today he
it.
is giving me the memo of calculation.
My lords, in fact, I was not even directed to file a memo of calculations. It is he who has. filed the
I'll
memo
have
of
to file
calculation.
it, my lord.
That was on 18th December 2023.
Very well.
Now, my lords, on 9th, with great difficulty, we moved this matter and we got it listed, my lords. And now they're seeking time, my lords. My lords, the history of litigation dates back to 2013, wherein already a round of litigation was done before your lordships, wherein this honorable court yet again directed us to approach the same family court and seek modification. After seeking modification, we are again before your lordships.
Under order,
On order dated 18/12/2023, learn counts for the husband respondent in RPFC number 148 of 2021
please.
has today handed over a demand draft for a sum of rupees 1,89,000 favoring the wife in
Please.
RPFC number 148. Learn counsel for the wife in RPFC number acknowledges, and so the learn counsel for the husband is directed to file a detailed memo of calculation by the next
Please.
date of.
Yes,
death. This was when 18/12/2023.
I agree, my lord. My apologies, my lord, because the matter has been transferred from Shobha Havipati, who has filed a memo for retirement. So she wants to retire and has given it to me, my lord. I was not aware of this order pass.
Yes,
Because
learn
it's not
counsel for the
available in the file.
petitioner, the request of learn counsel for the husband. Pose this matter on 20th. By the time the memo of calculation shall be placed on record, or else orders will be passed basing on the.
My memo, I've already filed, my lords, may be taken.
Counsel for the wife has filed the memo.
Grateful, my lords.
They was taken on record.
My lord, can it be taken on 23rd?
23rd.
Please, my lord. I'm grateful.
Grateful.
Till number 36.
For respondent in this case.
Satima.
Already filed
Petitioner.
for respondent.
I have served the counsel before the family court. I think he's filed the wakalat
To
also.
appear, he's already appearing.
Already I have filed wakalat.
Oh. The counsel for the, already wakalat is filed on behalf of the respondents. No. Why this, they find like this? No, there is a respondent appearing. It's okay, but when the respondent is already appearing, why should they unnecessarily post these matters like that? They should use the brain. No, direction will be there if respondent is present. Then comes for the, already a wakalat is filed on behalf of the respondent. Post this matter for preliminary hearing. Yes, next.
Please.
Cell
Great.
number non-compliance.
Look, any date,
It will come up.
correct, no problem.
Cell number
Yes.
37, P Mahesha, for applicant, the subjector.
No representation for dismissal. Tomorrow.
Cell number 38, P Mahesha.
Same,
Cell number 39,
same.
number 40. Same. 41,
Yes,
cell number 42.
yes, same advocate.
Yes. ma'am. This one.
Mhm. This will be the 2:30. There's many matters of it. Oh, office objections. One is already adjourned, I think, no? We'll call this admission matters.
Cell number 1. Neeraj.
Suspends petition, my lords, challenging the maintenance granted,
How much is granted?
7,500.
7,000?
500.
Hmm.
He is unemployed, my lord, senior citizen.
Huh?
He's a senior citizen and he's unemployed.
How
He has
old
wo-
is he?
He's 60 years.
Hmm. Divorce is granted.
Divorce is granted.
When?
2023 divorce is granted, my lords, but since 2005 they are apart, according to us. According to her, my lords, since 2017 they are apart. And she is living by her own, and she has a property, house property, she has a site. She's living with her sister.
Let him deposit half of that. 3,500.
Wait.
How much he has been paying till now?
I don't think so, is paid because only
Please
April,
get instructed. That's the case, then
my lords,
it's
only
from the
April,
date of petition.
April order is passed.
No, what is the order?
Order is 7,500 my lords, only in the year.
Finance, so the respondent that we want to the petition. From the date of this petition,
Petition,
that is 27/7/2023.
23.
So how many months? 7 plus,
Around 13, 14 months.
5 plus, sir, 9, 14 months.
Around 42,000.
56,000. 4,000. The land counts for the petition submits that. The petition is a senior citizen. And he has no source of income.
No source of income.
Source of income, and without considering all these aspects, voted granted an amount of ₹7,500 as maintenance, considering the submission of the counsel for the petitioner. There shall be stay of all further proceedings, pursuant to the order dated so and so, on the condition that he shall continue to pay an amount of ₹4,000, the 5th of every succeeding month, and shall depart, and towards arrears, an amount of ₹56,000 shall be deposited within a period of 6 weeks from the date of receipt of the copy of the order.
8 weeks.
Notice, 8 weeks. Notice to the respondents. Yes,
Cell number 2. Chandana B Somanna. Abhinav Ramanan.
Lords, on the last occasion, the respondents have sought time to make further submissions.
yesterday's matter,
Yesterday,
where is he?
he was here in the court.
Inform him. Yes, Nick.
Cell number 3. Yes, Ganesh.
Yes, Mr. Ganesh. You have muted your audio.
Sir, please unmute your audio, sir.
Yes, ma'am.
Ah.
My children filed 125 proceedings against me, my lord. They have attained the majority.
Let's see the order.
Getting that. Sorry, my
So an application filed seeking maintenance is dismissed.
no, it is not dismissed. My application, rejection of their application is dismissed. Because my contention is, see, they have attained majority, therefore they are not entitled to claim maintenance under section 125 CRPC. And
No,
again,
I'm
at
not able
time,
to understand on the
filing
maintainability of
of-
it. I'm not able to understand on the maintainability of it. Why it is not maintainable?
No, it is maintainable.
final
Sorry,
order.
today morning I made a mistake. My statement is that.
Huh?
Sorry, my lord.
What is he saying?
No, it is maintainable.
No, you are saying that it is not maintainable. Office has raised an objection with regard to maintainability. You are also
Yes,
saying
it is-
that it is
it-
not maintainable. Why it is not
After
maintainable?
going the court said it is maintainable. My lord. It is not an internal.
It's a final order.
It is maintainable, my lord. RPFC is it is maintainable, my lord. I may read section 19(4), my lord.
The RPFC is correct from the take that. So it is maintainable RPFC, otherwise what they will find. The office has raised an objection with regard to maintainability of the petition. In view of section 19(4) that this is an order passed under 125 CRPC, the final order, and the RPFC is maintainable. Goes the matter for admission. Office objections are overruled. This next 4.
Number 4.
This matter, I am appearing for the respondent wife.
Appellate.
And filed an application for seeking direction to the trial court to release the maintenance amount deposited by the petitioner. Number 144, filed by.
Yes, deposited before the trial court.
Yes, yes. They have
No,
deposited.
where is that application seeking permission to withdraw? You filed IA.
Yes.
Where is the counsel for the petitioner? Oh, this is coming up for dismissal.
No, it is for hearing on IM. Serial number.
No, yesterday also he was not there. That's what this posted for dismissal.
Based on order.
When the matter came up on so and so, there was no representation on behalf of the petitioner. The matter is posted for dismissal today. Today also there is no representation. Then comes to the respondent submits that as per the orders passed by this court, the husband has deposited the amount and the wife is permitted to withdraw the same accordingly. The wife is permitted to withdraw the amount deposited with the husband. Yes.
Please.
Let it be there. Yes,
Number 1.
please, pass over, Martha.
This number 1, serial number 5.
Yes, I appear for appellant.
Direct
This
there.
is the claimant's appeal against the impugned order passed by the Railways Claim Tribunal. That in dismissing the claim petition filed by the dependents of the deceased. And, in fact, last date of hearing, my lord, your lordship heard the matter in part as my learned friend was not audible through VC. In fact, my lord, the deceased while traveling, he was possessing the valid journey ticket, which is at next year A8 is produced. Only Railways Claim Tribunal may not on probabilities and on imaginary basis may not dismiss the claim petition. At para 12 may not last date of hearing may not it is.
Give those two judgments. Railway claims, but two judgments are there, mine and one more. The other day, railway claims. So only ground that is taken by you is that it must have been the ticket is it is a planted one or something. That's the only ground taken by the railways.
No, my lordship. Actually, the ticket, the deceased person traveled from Ramgiri to Mayakonda only, whereas the ticket is issued from that is Ramgiri to Davangere. That's why it is only contradictory point one.
What is that? I'm not able to understand. What are those places? So the accident place is where beyond Davangere.
No, my lordship, like this. First Ramgiri comes. After that Mayakonda comes. After that Davangere.
So his destination is Davangere, but accident has taken in the middle of his
Yes. That is only contradictory mechanism. Whereas he traveled, the deceased person traveled along with his son-in-law, that is the Malay Shappa, who is a teacher. On that day, on 24, when the incident took place on 24/11/20, actually he was on duty as per the muster roll of the school. How can he travel along with the deceased person? Moreover, railway gate person saw the deceased person was gauging the cat.
That submission you're making from which page or paper the court can understand, which para?
Yes, my lordship.
He was traveling along with his son-in-law and you have adduced the evidence to show son-in-law was there in his school on that day.
Yes.
Where is that?
That as per the report of the RPF, my lordship, that is inquiry report.
Then you have to adduce that evidence before the court.
Yes, it is there, my lordship.
Please read it.
AW.
That page
Which is
number
that?
60, BCR L1.
In the judgment, where is in the order, where is the discussion?
In the judgment itself, in the order itself, that is noted, my lordship.
At para 14, madam, page 14, at para 14, relying upon the above conclusion.
Moreover, ticket has not been recovered from the dead body of the deceased person. It is a bogus claim.
Where is that master roll? Where is it marked, the master roll?
Master rule is not, but it is as per the report, inquiry conducted by the RPF. That is revealed, my lordship. Actually, he was on duty on 24/11/2000.
Not necessary that it should be placed before the court. Who's that? Mhm. He belongs to the said village.
My lordship?
He belongs to that village.
Yes, that the nearby Mayakonda. It is but from Mayakonda railway station, it is 1.5 kilometers from the railway station.
Ticket is from,
Ticket from Ramgiri to Davangere.
what is that, Raman?
Ramagiri.
From that Ramagiri, where the dead body is found, that is how much distance?
It may be about 20 kilometers, my lordship. 20 kilometers. From the Mayakonda railway station, his village is still far away from the railway station, 1.5 kilometers. He is a 70 years old man.
No, why are they saying that they have boarded the train at Mayakonda, no, that whatever the place they are saying,
He
when they belong to
boarded
the
the-
other place?
No, my lord, my case is, my lord, he boarded the train at Ramagiri only, Ramagiri to Davangere. My lord, he purchased the ticket from Ramagiri to Davangere,
What is that, Ramagiri?
Ramagiri, Ramagiri, in the synopsis.
My lordship, starting point Ramagiri, where there is a temple, one big temple is there, Ramagiri. From Ramagiri to Mayakonda, the deceased person belongs to Mayakonda nearby village, Mayakonda. From Mayakonda to Davangere, the train starts, travels. But the deceased body found near the Mayakonda railway station, nearby near the track of the Mayakonda. Whereas the ticket is for the from that is Ramgiri to Davangere. How can we imagine that it is a bona fide passenger?
What is the explanation? Why did you go
My
to
lordship,
Ramagiri?
one more point, my lordship.
May I clarify?
Your,
Yes,
the
yes.
son-in-law,
I will say.
Sanina in
The
Davangere
ticket-
school, Davangere school.
When a ticket is from Ramagiri to Davangere. The Mayakonda where he fell down, it is in between down.
You are a resident of
My lord, I am the resident of, my lord,
Mayakonda nearby Uchavanahalli, 1.5 kilometers from the railway station.
Your son-in-law is working in Davangere. So the person, the deceased who belongs to Mayakonda,
Please.
why did you go to Ramgiri?
No, he-
And the son-in-law who is working in Davangere, what is he doing in Ramagiri?
Please.
And as per the master, that son-in-law is working on that day.
Please, he went for Ramagiri for visiting to the temple along with his son-in-law.
Yes.
He purchased the ticket from Ramagiri to Davangere. He boarded the train at Ramagiri. In between that, my lord, Mayakonda, Sallu railway station, he fell down. This is the version.
Then what do you say about on that particular day, that son-in-law was already is in the school?
No, son-in-law was not in the school, my lord. May I take your lordship kind attention to para 14?
Time I will
So
quote
far
the
as
master
that,
roll also.
my lord, so far as that version is concerned, they have not led any evidence. There is no evidence at all.
According to the claimants, how he fell down, how the
Please,
accident
please,
has happened.
according to the claimant, may I take your lordship kind attention to the brief facts, my lord. He boarded the train at Ramagiri.
Let's see, read
Please.
from that.
Please, my lord, while, my lord, due to the jolt and jerk, my lord, he explained that while he, due to the heavy rush, and while he was proceeding to the nature call, my lord, due to the jolt and jerk, my lord, he fell down.
What is the time of accident?
Please, time of accident, my lord, he boarded the train at 2:30 PM and time of accident is not mentioned. But however, in between after 20 kilometers, after 30 minutes, at 2:30, he boarded the train. After 30 minutes at about 3 PM, my lord, their defense is only two. One is, my lord, gateman has seen this person while he was grazing the cattle. He has not been examined. That too, my lord, he had seen him at 12 PM. And thereafter, he boarded the train at 2:30. There is a long gap between that time also. Even assuming that, my lord, he has seen, my lord, he has not been examined, the railway gateman. And moreover, my lord, section one
Please
twenty,
read 11, that I.
please,
section is
one
good.
24A is a beneficial legislation. My lord, in fact,
Doesn't mean that.
that doesn't, I agree, my lord. I
authority-
agree. Once, my lord,
Come to para 11,
please,
para 11.
para 11, please.
Yes.
Para 11, my lord, AW2, Mr. Malleshappa, son-in-law of deceased during his cross-examination before the tribunal. Apart from admitting that he is not an eyewitness to the incident, and he personally does not know anything about the incident, he has stated that on the incident date, he attended Kanaka Jayanti function in his school at Davangere, and the function got over at 10:15 a.m. It is about 40 meters from school, Davangere railway station, at about 10:25 a.m. He was in the station. He purchased 2 tickets at Davangere railway station and another one for Asadi Basappa. AW2 further volunteered and stated that he had purchased combined ticket for both of them. It takes 15 minutes from Davangere to Mayakonda. Deceased had came to Mayakonda station and boarded the same compartment where he was sitting. They went to Ramagiri to perform puja to Gavisiddeshwara and Harisiddeshwara, which is situated at mountain in Ramagiri. Deceased, who was aged 76 years, climbed 337 steps to reach the temple. Mayakonda is the nearest railway station for the deceased. He and the deceased traveled in the same compartment. Deceased went to attend nature call, but he did not return up. He received information by message from one of his relatives from Uchavalli around 8:50.
What is the statement the son-in-law gives? Can it be believed?
So it is my lord, both of them, my lord, he purchased the
But till 8:15 in the night, he's not even bothered. What happened to him?
No, that may be,
My
my lord,
lordship,
that
duty-
version, my lord, not explained in a proper manner. However, my lord, both of the version is, my lord, he purchased the ticket for both of them. He boarded first. His father-in-law boarded next station, and
The
both
same
of them.
compartment, both of them were sitting. They went to the
Yes,
temple,
yes.
they came
This
back.
is his version.
They came back.
They came.
Then after that, what happened to him? He doesn't
What
know.
happened to him? He did not inquire. That is his version. But I agree, my lord. However,
The
only on the
court's
probability.
finding appears to be correct. Here at.
No, court finding is only this, my lord, on
14.
probability and imaginary.
No, 14, come to 14.
Please,
Para
para
number 14 last. As per the statement given by Baswaraj,
Yes.
Siddhappa, gateman deceased was found with buffalo at 12 hours and he instructed him
please.
not to move nearby
My lord,
track as dangerous.
entire para 14, I will
Yes.
read, my lord, please. Relying upon the above conclusion, respondent argued that as per the muster of 24/11/2010, AW2 was present in the school. In that case, how he has accompanied the deceased in his journey to Ramagiri temple. The deceased native place is of 1.5 kilometer from away from Mayakonda railway station, but the ticket furnished by applicant's exhibit A8 reads the ticket from Ramagiri to Davangere. Instead of Mayakonda, AW2 has not handed over the ticket at exit gate of railway station at Davangere, but handed over the same to GRP after deceased death. The deceased residence is Uchavalli, which is 1 kilometer away from the spot. As per the statement given by Basuraj, Siddhappa, gateman bar Mayakonda, deceased was found with buffalo at 12 hours and he instructed him not to move nearby track as trains are passing. Moreover, deceased was deaf. Train number 581 passenger passed Mayakonda at 6:18 hours, whereas the villagers have noticed the dead body at 15 hours.
15 hours means how much? What is the time?
15 hours, 12 plus 3
o'clock.
5 o'clock. 15 hours, 3 o'clock.
3 o'clock.
3 o'clock. 2:30 he boarded the train. 2:30 he boarded the train. He fell down after 30 minutes. That was the real cause. And even, my lord, your lordship may kindly see section 124A. My lord, only exception is, may I take your lordship kind attention to section 124A, my lord.
Yes.
124A.
Yes.
Even assuming that, my lord, that is not my case. I'm having valid journey ticket. I'm the passenger in the train. That is my case.
So the burden is fastened upon the railways too.
Please,
Move
even in that manner also, only exception to the section 124A, may I read your lordship and attention. Compensation on account of untoward incident. When in the course of working a railway an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of the railway administration, such as would entitle a passenger who has been injured or the defendant of a passenger who has been killed to maintain an action and recover damages in respect thereof. The railway administration shall notwithstanding anything contained in any other law, be liable to pay compensation to such extent as may be prescribed, and to that extent only for loss occasioned by the death of or injury to a passenger as a result of such untoward incident, provided that no compensation shall be payable under this section by the railway administration if the passenger dies or suffers injury due to suicide or attempted to suicide by him, self-inflicted injury, his own criminal act, any act committed by him in state of intoxication or insanity, any natural cause or disease or medical or surgical treatment, unless such treatment becomes necessary due to injury caused by the said untoward incident. Next explanation for the purpose of section passenger includes.
So first of all, he should be a passenger.
First of all, he should be a passenger. And even this section 124A includes that even though he is not a passenger, on the while on the your lordship, on the course of working the railway,
No, it's not that.
Pardon?
Anyhow, the disease was not, is not working.
On the course of working the railway, even the crossing the passenger, even he is not a bona fide passenger. While he is crossing, if met an accident, it covers. Even assuming for a moment, my lord, if the person is not.
Paul, your case should be clear.
My case is not that. My case
Either
is,
you have to be that side or this side.
no, I
can't-
initially only I
So, no,
submitted.
your-
It is
your
not my
case
case.
is that-
It
your
is
case
not
is
my
that you're
case.
Passenger.
Yes, my lord, initially I submitted that, my lord.
Stick to that.
Yes.
You're a passenger.
Yes,
And,
I'm the,
You are not a passenger is their case. It is not you are not a passenger. You are not, the injuries that are sustained by you are not while you were traveling is their case.
my lord, I followed.
That's what,
My
that is-
case, my lord, I am having, whenever, my lord, I am having the journey ticket, which is at exhibit 8, that suffice, my lord, he is the bona fide passenger. The burden, is on the other side, my lord, on the railways to disprove that he is not a bona fide passenger.
Yes,
Once I produce the journey ticket, my lord, it presumes that, my lord, I am the bona fide passenger. And adding to that, my lord, I have adduced the evidence. And evidence, my lord, the son-in-law.
That is where your evidence is the problem now. Even if you don't have a ticket, then also you would have got compensation.
Please, please.
With your ticket and with your evidence, that's what is making things complicated now.
No, evidence is, my lord, only the discrepancies, my lord, he
Say-
did not care.
You
He
say
did
a
not,
person of 76
I agree, only one
has got,
discrepancy.
337
Yes,
steps
my lordship.
up and down.
Correct.
And again, he came to the place, he is traveling.
He was traveling that evidence, my lord, till, my lord, he was traveling along with.
Yes, when the person is, this deceased is from Maikonda, why a ticket for Davangere is purchased is also not known.
No, he, my lord.
And now, for example, okay.
No, in the evidence. it is-
Son-in-law wants to take him to Davangere. No, the son-in-law says till 8 o'clock, I didn't even know, I didn't even find out where he is.
No.
If that is the case, then why did he purchase a ticket for Davangere?
No, he boarded the train from Davangere. Son-in-law.
That is first, you're telling about the first step. They boarded it, they went to
Correct.
the temple,
Please.
while coming back.
Please,
Now the ticket, what is relevant is that ticket. That
correct.
is from Davangere, what is that,
Ramagiri.
Ramagiri to Davangere.
Correct.
That is the relevant now.
That is the
Now, what
relevant.
the first ticket is not the relevant one.
No, it
So,
has no relevance.
From Ramagiri to Davangere, when this person belongs to this place, why was the ticket taken to Davangere? Maybe he has taken the ticket to Davangere to take the father-in-law to his house.
Please.
In that case, what he says is, he went for something, I don't know, till 8:15, till I get a call from someone, I didn't even know what has happened to him. So how is it probable?
Only that version, my lord, I followed. However, other version is, my lord, from Ramagiri to Davangere. He intend to take his father-in-law to the Davangere. There is no discrepancy. Ramagiri to Davangere. In between that, he fell down. Thereafter, my lord,
If he fell down, then how much time it takes from
that,
this Ramagiri to Davangere to reach?
that I agree, my lord. That version, I really agree, my lord. He
After
could have
getting down- after
searched.
Getting down from the train, someone is, it's normal human conduct that they will find out where the father-in-law is, who is aged 76 years old.
No explanation is properly elicited in that version, and that I do agree. Only because of that is the discrepancy in the evidence. My lord, the ticket, my lord, it cannot be believed that there is a valid journey ticket, and he fell down. And my lord, he met with an accident, that is an untoward incident.
Now, the son-in-law, he went to his house.
Please.
What is the finding about the ticket? He will be carrying the ticket home.
No, that is the finding, my lord. He had carried the ticket. He has not even handed over the ticket in the gate also, outside gate also. That is the finding of the tribunal. My lord, thereafter, my lord, he has given the ticket to the concerned department. My lord, he explained that, my lord, he was accompanied with his father-in-law. Both the journey he explained, not only one journey, as your lordship pointed out, my lord, from Davangere, the Mayakonda to the temple, my lord, and return from that. Both the journey he has explained, not in one journey. If it is one journey, my lord, your lordship I could have considered that, my lord. Mayakonda, he visited to the temple. That journey ticket, we are not concerning about that. That also he explained. And return back to the temple from the purchasing the journey ticket, my lord, from Ramagiri to Davangere. In between, my lord, he fell down.
How much time it takes from Davangere to Ramagiri?
Ramagiri to Davangere, my lord, I am not.
1 hour, my lord.
1 hour, my lord.
Nearly 1 hour.
In between,
No,
he fell.
according to him, he has boarded the train at 10:30. So he might have reached Ramagiri at 11:30. Then the old man starts climbing the to the temple for the darshan, 327. He'll climb, he'll get down. Then after that, he'll catch the train at 2:30.
Thereafter, he boarded the train.
Possible.
Apart from that, my lord.
My lord, first he visited the temple. This is the second.
No, at 10:30 he visited the temple.
Correct. 10:30 they visited.
10:30.
Boarded the train at 2:30 p.m. for returning to the Davangere.
For them to reach Ramagiri, Ramagiri itself, it takes till 11:30. After 11:30, you should start climbing they should reach the temple.
No, first they visited the temple, madam. Thereafter this journey. Journey is.
That's what visiting.
This journey is after visiting the temple.
I am calculating it from 10:30, where the son-in-law from the school started, from Davangere.
Correct.
Started from the school at 10:30.
10:30.
By the time he reaches that place, 11:30. 1 hour you are saying that, 11:30. After that, from the railway station, they have to go to the temple. For having the darshan, they have to climb. Again, they have to get down. And then they have to come to the railway station.
Correct. At 2:30. At 2:30. My lord, 10:30 a.m. he was in the school. The railway station is only 1.5 kilometers from the school. That is that he has explained.
11 o'clock. Then it is 11 o'clock by the time he reaches the railway station.
Please.
Whenever he comes, the train won't be there. Then train will be as per its schedule. So 11 o'clock. By the time they reach Davangere, and train exactly on 1 hour, it might not go. So even assuming 12 o'clock, from 12 o'clock to the place, to the temple, for getting onto the steps, he has to go there. From then 327 steps at the age of 76, however athlete he is, it will take a lot of time. Get up to get onto that and again come down.
No,
It's
that
not a
question, my lord,
normal place, no.
in
Please
fact, that all, my lord, my only submission is, my lord, I am relying upon once the journey ticket is.
Please pass on the
In
judgment.
Veena Devi case, my lord.
Yes,
Veena Devi,
it is here.
yes.
Then the other day also I have passed an order.
In
basing
Veena
on
Devi
that.
case, my lord, the proposition of law is this, my lord, once, my lord, the passenger is having a valid journey ticket, on probabilities or any imaginary basis, my lord, this claim petition, which is a
Where is
beneficial,
the judgment?
but it cannot be it cannot be rejected, because as my
Page
lord,
number 16, my lord.
once my lord, he is having valid journey ticket, and it is suffice to say that, my lord, he is a bona fide passenger. On the imaginary basis or probabilities or some discrepancies in
You're relying
evidence.
on Reena Devi's judgment?
Please.
Yes.
Please. My lord, last last in my citation, my lord, para 17.4,
Yes.
Last conclusive para.
Hmm.
Before that also, my lord, para 12, para 24 and para 28 is also the relevant. However, my lord, for a moment, my lord, I will take your lordship kind attention to the last para. Whereas-
Para number 29 of the judgment, what it says?
Correct, my lord. We thus, it starts from we thus. We thus. Para number 17.4 in my judgment, it is, we thus hold that mere presence of a body on the railway premises will not conclusive to hold that injured or deceased was a bona fide passenger for which claim for compensation could be maintained. However, my lord, this is important. However, mere absence
this
of
will-
ticket, even in the absence of ticket,
That's what I said. Now you don't fall for, this judgment will not apply to you. In fact, it applies against you. It says mere presence of a body on the railway track is not sufficient to claim compensation.
that is one first phase, my lord.
Because in the case, no, basing on that case, I passed another order last week. So your case will not fall under those
So
parameters.
that is first phase, my lord. Next, my
Yes.
lord, however, your lordship may kindly, however, mere absence of ticket
Hmm.
with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift upon the railways. Even in the absence of ticket, the claimant can prove it by way of filing a affidavit.
That's
Once he filed an affidavit, the burden is shifted on the railways to disprove it. In my case, my lord, it is a better case, my lord, we are having the valid journey ticket. Even in the absence of ticket, the Honorable Supreme Court, what it held that even in the absence of journey ticket, it can be adduced by way of evidence.
Yes.
In such a situation, it is the burden lies upon the railways to disprove it. That is how, my lord, my submission will be this. It is a better case, it is having a valid journey ticket. And journey ticket, my lord, only on the basis of some discrepancy in the evidence or timings, or my lord, imaginary or probability basis. This beneficial claim petition cannot be, it would not be a fair, or it would not be, unless, my lord, the claimants would,
Yes. Agreed with orders passed in OA 2U 126 of 2011 dated 2nd June 2016. The claimants are before this court. The claimants have filed an application seeking compensation of an amount of rupees 4 lakhs under section 16 of the Act from the respondent railways for the death of the husband of the claimant.
no, mother, hello, sorry, I'm sorry. The wife of the
deceased.
The first claimant is wife of deceased.
And our daughters.
Saying husband of the claimant. Husband of the claimant. It is the case of the applicants that on 24/11/2010 at about 2:30 PM, deceased boarded the train after purchasing ticket and started journey from Ramagiri to Davangere along with his son-in-law. During the journey in between Maikonda/Sasalu railway station, deceased while returning from bathroom due to high-speed jerk and jolt of the train, he fell down from the running train and succumbed on the spot. The respondent railways have denied the claim, stating that he was not a bona fide passenger and the ticket furnished by the applicant is a planted one, and the incident has not occurred in the manner stated by the applicants. It is a case that the deceased might have trespassed into the railway property without authority of law and valid ticket. Therefore, under section 124A of the Act, applicants are not entitled for any compensation. The court had dismissed the application filed by the applicants. While dismissing the application, the court had considered the evidence of AW1, that is the wife of the deceased. The wife of the deceased in a cross-examination has stated that deceased was working as a coolie and he used to graze cattle. And on the day of the accident, he left the house at 10 a.m. in the morning, saying that he would be going to temple at Ramgiri. He also told her that he's going to temple along with the son-in-law. Then AW2 is Malleshappa who is the son-in-law of the deceased. It is his case that he is not an eyewitness to the incident. He personally does not know anything about the incident. It is stated that on the incident day, he attended Kanaka Jayanti function in his school at Davangere, and the function got over at 10:15 a.m. It's about 40 meters from school to the Davangere railway station. At about 10:25 a.m., he was in the station. He purchased 2 tickets at Davangere railway station, one for his father-in-law. It is stated that he has purchased combined ticket for both of them. It takes 15 minutes from Davangere to Maikonda. Deceased had come to Maikonda station and boarded the same compartment where he was sitting. They went to Ramgiri to perform puja, which is situated at mountain in Ramgiri. Deceased, who was aged 76 years, climbed 337 steps to reach the temple. Maikonda is the nearest railway station for the deceased. He and deceased traveled in the same compartment. Deceased went to attend nature calls, but he did not turn up. He received information from one of his relatives from Hochevalli around 8:15 p.m., saying that the deceased died due to falling down from the train. On behalf of the respondent railways, to substantiate their case, they filed DRM's report, which is marked as Exhibit R1. After thorough inquiry, as per their thorough inquiry, it is concluded that the journey ticket appears to have been planted to prefer the claim, taking advantage of the claim provision in railway accidents, and the claim deserves to be dismissed as false claim. Further, it is their case that as per the muster of 24/11/2010, the son-in-law of the deceased was present in the school. The court has observed that in that case, how he has accompanied the deceased in his journey to Ramgiri temple is not known. Further, the court has also observed that the tribunal has also observed that the deceased native place is 1.5 kilometers away from Maikonda railway station. But the ticket furnished by the applicant reads the ticket is from Ramgiri to Ramgiri instead of Maikonda. The son-in-law has not handed over the ticket at the exit railway station, but handed over the same to JRP after deceased death. Deceased residence is Uchavana Halli, which is 1 kilometer away from the spot. And as per the report given by the gateman, that he found the deceased with a buffalo at 12 hours, and he instructed him not to move nearby the track as trains are passing. Moreover, the deceased was deaf. The villagers have noticed the same, noticed the dead body at 15 hours. The tribunal has also observed that it is not possible to visit Karisiddeswara Swami temple, Ramgiri, within 1 hour, which is situated on hill and having more than 300 steps. And the tribunal had come to the conclusion that the deceased was not a bona fide passenger. The court also observed that there are many contradictions in the statements of AW1 and 2, that is the wife and the son-in-law. As per son-in-law of the deceased, he has purchased 2 tickets at 2:30 p.m. But information regarding deceased death was given by the gateman at about 18:40 p.m. The court has also observed about the evidence of the son-in-law that he has come to know about the incident at 8:15 p.m. And if he is, along with this father-in-law, he cannot be at the school at the same time. Considering the evidence of AW, the wife, the son-in-law, and also the gateman, the court has come to the conclusion that was not a bona fide passenger and ticket is planted in this case. Even if it is proved the defendant had fallen from train, since bona fide status of the deceased as a passenger at the time of the incident is not proved, applicants are not entitled for compensation. Agreed thereby, the appellant is before this court. Appellants are before this court. Land counsel appearing for the appellants submits that the court had in fact fastened the burden on the claimants, whereas the burden lies on the railways to prove that it was not an untoward incident and is not a bona fide passenger. He submits that in the Honorable Apex Court in Reena Devi's case that's reported in 2019 3 SSC 572 has observed that once they file an affidavit narrating the incident, the burden lies on the railways to disprove their claim, and even has gone to the extent of saying that mere absence of a ticket also cannot be a ground for the railways. Say that he is not a bona fide passenger. Land counsel submits that when they have produced the tickets to show that he was traveling, that itself is sufficient. And basing on assumptions and presumptions, a claim cannot be, the claimants cannot be, the claim petition cannot be dismissed. They submitted that the evidence of the witnesses and the tickets that are placed before the court proves that they have discharged their burden, and the railways have failed to substantiate their case, and in spite of the same, the trial court has dismissed their petition. Next part. Land counsel appearing for the railways submits that the tribunal had rightly dismissed the petition. He submits that the manner in which the accident had happened and the narration, the how they have narrated the whole episode, right from purchasing the ticket from Davangere to Ramgiri, and from Ramgiri to Davangere, considering the age of 76 years, the age of the deceased, the evidence of the son-in-law, and the place of visit, the temple, and all these things proves that only for the purpose of claiming the compensation, they've come up with this case. Land counsel submits that the gateman has stated that he knows the deceased and he saw him at 12 o'clock. Which also disproves the case of the claimants that at that time he went to Ramgiri along with his son-in-law. And in fact, the son-in-law was very much available in the school in Davangere as per the muster roll. All these things flinchingly prove that he was not traveling in the said vehicle. It's traveling in the train as stated by them. Expert. Having heard the counsels on either side, that is the material on the part. Before going into the merits of the matter, it is appropriate to look at section 124A of the Railways Act. extract 124E. Relying on this provision, land council submits that this is an untoward incident and the claimant is entitled for, claimants are entitled for compensation. You have the judgment, Ramgiri,
Pardon?
the judgment pass on,
Reena Devi judgment, ma'am?
Rina Devi.
Yes. More mirrored on facts.
Honorable Apex Court.
A4 is the inquest report. For a moment, I intend to take your lordship kind attention to the A4 is the inquest report, my lord. May I take your lordship kind attention to, my lord, para 4 of the impugned judgment. Internal page 4, para 12. Para 12. Second para, my lord, in that. Exhibit A2 is the inquest report. In this report, wide para 12, my lord, Panchas opined that on seeing the incident spot injuries and based on the statement of relatives as well as one Mr. A.K. Malleshappa, who is the deceased.
Now.
When the deceased was alive, I will read further, my lord, was alive, was traveling from Ramagiri to Davanagere, fell down from the running train, accidentally sustained grievous injuries and succumbed on the spot. It is his statement. His friend, my lord, A.K. Malleshappa. This is his friend, my lord. He is one of the relative, my lord, statement of relatives as well as one Mr. A.K. Malleshappa. He has stated, my lord, in the inquest report, is the A2 is the inquest report. It also supports. There is some witness is also there. So these are all the.
Example, as per the evidence of the gateman, he was grazing the.
Gateman is not examined. Gateman is not examined.
If he is, no, if he's grazing the thing and there he fell down on the train, if the accident takes place, whether he's entitled for compensation or not.
No. Even
Not he fell from the train.
he is entitled.
He's entitled,
He's
but
entitled.
that's not your case.
That is not my case. Once I putting on this journey
Not
ticket,
your case.
even I agree, my lord.
So
Even while grazing
The inquest report says that the injuries are, he has sustained the injuries. Maybe his body was found on the
track,
track.
railway track.
If your case is the other way, then all these things we would have considered.
No.
But the case which you have put forth about all this 10 o'clock, 10:30 to Davangere to Ramgire to temple to back, and the son-in-laws.
No, timings, my lord, in fact, there is no vary in my lord, submission. There is no such variation in the timings. Your lordship is very key, my lord, timings. Hence,
Yes.
my lord, only because of
And
that.
you have submitted and
A2 is a request, it may be taken on, right?
Huh?
A2, exhibit A2.
That also I'll record.
Inquest report, and one person, A.K.
Yes.
Malleshappa, has supported.
Yes. The Honorable Apex Court, in judgment, in Union of India, Srina Devi reported on, sir, I think that's already did. So and so had considered the scope of section 124A. The court has observed that has held that the mere presence of a body on the railway premises will not be conclusive to hold that injured or deceased was a bona fide passenger for which claim for compensation could be maintained. However, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railway. And the issue can be decided on the facts shown or the attending circumstances. This will have to be dealt with from case to case on the basis of facts found. The Land Council has also relied on Exhibit A2.
Please.
Exhibit A2 is the inquest report. In that, the Panchayats have opined that on seeing the incident spot, injuries and based on the statement of relatives, as well as one Mr. A.K. Mallesappa, deceased when alive, was traveling from Ramgiri to Davangere, fell down from the running train, accidentally sustained grievous injuries, and succumbed on the spot. Thus, death of the deceased is an accidental one. Land Council basing on this submits that all these prove that the accident had taken place and the deceased was traveling in the said train and fell down, and he had sustained injuries. As such, he is entitled for compensation. There is no dispute about the fact that the Honorable Apex Court in the above referred judgment has stated that once the claimants files their affidavit, they are narrating the reasons how the accident has happened. The burden lies on the railways. That case where the court had dealt with where there is no ticket with the passenger, according to the Land Council, according to the Land Council, in this case, in fact, he's also having the ticket, and his case is a better case. When the claimants have stated that in a particular manner, the accident had taken place, that they are traveling from one place to the other. They're traveling along with so-and-so. And when the narration and the manner in which they have narrated the incident, that itself raises any amount of doubt that has to be has to be looked into by the court. In this case, the son-in-law is staying in Davangere in a school. He has boarded, according to him, there was a function in his school till 10:15. Thereafter, he went to the railway station. At 10:30, he boarded the train. He has taken 2 tickets for him and for his father-in-law. His father-in-law has boarded the train at Maikonda. From there, they went to Ramgiri. It is the case of the son-in-law. From that Ramgiri, they have gone to the temple. They have reached the temple, and he and his father-in-law had the darshan of God by climbing 300 and odd steps. Thereafter, and again, they climbed again. They got down those 300 odd steps, and he has taken the tickets from Davangere, from Ramgiri to Davangere. According to him, after boarding the train, the father-in-law went to the washroom. Then he went to Davangere. And later at 8 o'clock in the night, they have come to know, somebody has informed him that his father-in-law died in the accident. He fell down from the train and he died. How the incident has been narrated, and when it is a specific case of the Railways Act, as on that day, the son-in-law was working, as he was working in a school, as per the muster roll, he was very much present in the school as on that day. As per their report, RDM report, what has been placed, the gangman has seen, the gateman has seen the deceased at 12 o'clock while he was grazing the buffaloes. And he also informed him that he has to be careful as the train will be coming. And further, it is also stated that the deceased is a deaf person. All these the facts, how it has even taken into consideration how the claimants have put forth their case. That itself shows that itself shows that he is not a passenger in the train. And if at all, the son-in-law has taken the tickets to Davangere to take his father-in-law to his house, he wouldn't, the evidence of the son-in-law saying that at 8:30 he came to know about the death of the father-in-law is unbelievable, and the tribunal had rightly dismissed the petition. This court finds no reason to.
Cell number 23.
23 appear for the petitioner, my lord. Appear for the petitioner, my lord.
Yes.
The petition filed by the petitioner for the maintenance was dismissed, my lord.
Yes. Let's see the order why it is dismissed.
Lord, yes, my lord. At the translated copy, I filed separately, my lord. May I read from the reasons, my lord? Last time also,
Yes.
my lord.
Yes.
Yes. Reasons, my lord. Point number 1. According to the details in the petition, since the respondent completely neglected the petitioner, for which petitioner number 1 started beauty parlor by borrowing loans. Even after that, the respondent who used to drink come near beauty parlor and behaved immannerly, for which most of the customers stopped visiting the beauty parlor. Suffering from financial clock, she started relying on her deceased mother. While this being so, during COVID pandemic, she left respondent and returned to her own native and started residing there itself, wherein the respondent completely neglected to take care of the petitioner. The respondent denied all these points and stated that since he became deaf and was incapable of continuing his driving profession, and hence he set up a beauty parlor to the petitioner number 1, and petitioner number 1, who started having income from the said profession, used to have inferior attitude against petitioner who is deaf and completely neglected him, and then she expelled him out of the house since had no income, and at present he is living under the shelter of his mother. Both the parties produced several evidences before the court in order to substantiate their arguments and objections. Among them, only few reliable evidences are taken for examination. It is undisputed fact about the relationship between the parties, and that the petitioner is residing separately from respondent, exhibit P1 to P5. Exhibit R, invitation, birth certificate, etc. Notice are all also undisputed and are supplemental to this case. Though it is the stance of petitioner that the respondent himself abandoned the house and have neglected her, the supplementary evidence to prove the stance of PW1 are not available before the court. Also, any factors admissible for the allegations are not brought out in the cross-examination of RW1. In exhibit P14, diverse notice issued by petitioner number 1 to the respondent on 28/12/2018, it is alleged that the respondent has caused physical and mental torture and abandoned her. But the document marked as exhibit P15 as regards to the discussion permitted to petitioner number 1 by Mysore Women Police Station on 9/12/2018 and excluding the medical certificate marked as exhibit P18 issued by the medical officers of Primary Health Care Center on 22/12/2018 and that she took treatment at Primary Health Care Center at Hale Agrahara on 10/1/2018 that her husband had assaulted on her about 3 days ago. There are no other documentary evidences before the court to conclude that the respondent has caused harassment on petitioner number 1. During the period of 16 years of marital life between petitioner number 1 and respondent. Moreover, PW1 herself during the cross-examination has adduced that she is not ready to live with the respondent. When all these factors are carefully examined, it could be concluded that there are no enough reasons to show that the petitioner number 1 is not capable of living together with the respondent. Hence, as provided under section 125(4) of Criminal Procedure Code, it could be seen that the petitioner number 1 who is living separately from respondent is not eligible for culminating maintenance from him. Moreover, the important point to be noticed here is that the petitioner number 1 has filed MC number 214/2022 before the first court against respondent seeking divorce. The said case was transferred to this court and the same was simultaneously inquired along with this court and the said divorce case was ordered under which petitioner number 1 got divorce from respondent. Despite there are no documents in this court, the said fact may be considered by the knowledge of this court. Hence, as explained in section 125 of Criminal Procedure Code, the petitioner number 1 does not come under the purview of wife, but she comes under divorced wife. And hence, though the divorced wife being petitioner number 1 has no source of income and the respondent is well stable in terms of income, if she prove that he has denied to take care of her and has neglected her, and then she would be eligible for maintenance from respondent till her remarriage or lifetime. When there is no question that petitioner number 1 is ready to live with her divorced husband, and since there is no need of adducing enough reasons to live. Milord?
I have seen. The court has directed the husband to take care of this educational expenses of the daughter.
Yes.
So the wife.
Daughter, no son, his son, he is studying in.
As far as the wife is concerned, it is rejected.
Yes, wife on maintenance, both rejected, only educational expenses for the son. He is studying in law now.
Yes. Yes, what do you
Lord,
say?
Here, he claims that I have the beauty parlor that has been closed because of his behavior only. He made me to close down that beauty parlor. I do not have any income and his income, my lord, he has got 3.5 acres of land, agricultural land. Not only that, he has a commercial building that he is taking rent, and also he has got cattle farming and all, my lord. And my lord, your lordship will kindly see, even he is a politician. For that, your lordship may kindly see the documents I have furnished before the court at exhibit. He is a active politician in a particular that is at my lord, exhibit P16 and P17.
Yes.
And he has sufficient income, and I have also many diseases. My health condition is also not permitting. And moreover, my lord, in this case, if at all, I have the income also, my little bit income also from the source, maybe, my lord, and I have furnished a compilation of citations separately before your lordship, my lord. Your lordship may kindly see that compilation.
Yes.
That is separately I furnish it before your lordship, my lord. Citations,
In spite
compilation of
having income,
citations.
she is entitled for maintenance.
My lord,
As for the judgments, in spite of her income,
yes,
still
she is
for
entitled for maintenance, even though she has got little bit income, she is entitled for maintenance. Maintenance is my statutory right. He has to provide me that maintenance, not only for me, now for my son also, because now he is a student. He has to be maintained. Now, whatever the trial court ordered is only and only for the educational purpose. That also he is not providing.
We are paying it, ma'am.
Yes. What is?
Yes, they are stating that there is a land for him. There's a commercial building. Not even iota of evidence has been produced before the family court. Not even one record has been produced that there is a land and there is an income from that. And she is running the beauty parlor. It's not closed. We can file an affidavit also to that effect. Mysore in main road itself, she's getting an income of monthly 60,000.
Not
This is
at all,
willful
my lord, not
desertion.
at all. It is absolutely false submission, my lord.
Let us submit, you can reply to that.
This is willful desertion, my lord. The honorable family court judge itself has noted in the judgment that she is not going to ready to live with him. So if she doesn't want me, but she
No,
wants more
what
money.
125 says that divorce wife again should
Yes,
go to
yes, my lord.
husband and then they will be given maintenance.
Yes, my lord. At the same time, this 125 also says that no wife who is entitled to maintenance if she deserts by herself, deserts a husband by herself and lives separately. So this is one aspect, my lord. And second thing is
The divorced wife.
Yes, my lord.
The granting maintenance to a divorced wife, where is the question of willful desertion there?
Yes, after that only she went and filed divorce after decision. Then my lord, kindly see para 16, and he is a deaf person. Other than driving, he doesn't know anything else. So for driving, we need the ears to be perfect. He is a deaf person and he is not able to, he is dependent on his sister who is an auditor, and he's paying the fees. They are telling they are not paying the fees. Already they have filed an execution application, and we have paid all the interim maintenance which was pending, and also the educational expenses we are depositing in the court, my lord.
Yes.
My lord, your lordship may kindly see the
What is the-
exhibits
Every
where
time, after every one sentence, if you want to reply, it's difficult. Let her complete. If you want to tell me whatever you want to submit, you submit. Court will hear. Yes.
And whatever the judgments they have produced, my lord. will
Not the
come to
judgments. What is the age of the child now?
20, my lord.
Huh?
20. He's working also in somewhere inside.
he is a law student, my lord.
And also working in YouTube channel, anchoring his.
What about maintenance to the child?
Maintenance, educational expenses means we are providing him everything. That I can get the statement from the, whatever he has paid before the court, my lord, in the family court, in the execution court.
Please come. Then counsel for the respondent shall place before the court. What expenses? The father is bearing. with respect to the, son, and what are all the amounts that he has paid so far? When can you?
Yes, my lord.
My lord.
When can you file?
When can you file?
I can Another week's time may be granted, my lord. Or something kindly posted on 25th or something, 30th. Obliged.
A date may be fixed, my lord.
39.
My lord,
39.
30th, my lord. Obliged.
Yes.
Sale number 26, LS Venkatakrishna for appellant.
Do that. This is an appeal of 2014. This was there in the advance list? No, it was there in the advance list, no? No. Earlier advance list it was. Earlier that we have printed. No. It was the list was prepared. This is a appeal of 2014. As a also representation on behalf of the appellant. The matter was directed to be, when the matter came up on 9/9/2024, as a result representation on behalf of the appellant, the matter was directed to be listed in the caption for dismissal. Today also, there is no representation on behalf of the appellant. Accordingly, the appeal is dismissed for non-prosecution. Yes,
Number 27. Ravi Shankar S.
what you call is 26 now.
7. Ravi Shankar S. P.G. Sriram.
Same, this also 9/9. Yes,
Sale number 27. 28.
yes, 28 also same 9/9.
Sale number 29.
Same order,
Sale number 30.
same.
B.B. Shivakumar. Sale number 31. 31 adjourned. 32.
Kindly have this matter on day tomorrow minutes.
Which case?
Seal number 31 minutes.
31 is already adjourned in the morning, I think. It's adjourned to 29.
Sale number 32. K.S. Naresh Santosh.
Same order. This is on 4/9.
Yes,
This
ma'am.
came up on 4/9.
Sale number 33.
Sir, I appear for the petitioner, Lordship. Lordship, my apologies, Lordship, on the last date of hearing, I was
How
not present.
many times the court has to invite you to come to the court?
Lordship, only on the last date of hearing, I was not present, Your Lordship.
Even before that also he was not there.
Yes. And 21st also, yes.
Four occasions you are not there. Right from 8/8/2024. Yes,
Lordship, I am sorry, Your Lordship.
yes.
Lordship, the order in the challenge is, Lordship, the interim maintenance granted by the family court to a tune of rupees 20,000, Your Lordship.
20,000.
20,000. Lordship,
What
the
is the
match,
interim order? What is the interim order of this court?
Lordship, interim order, Lordship, this court modified the interim order to 10,000, Lordship. And I have paid till date, I have paid the Lordship 10,000 at the rate of 10,000, Your Lordship.
3 months arrears is there. Last occasion I made
So
submission.
he has to
Lordship,
pay another 30,000.
Lordship, I have obtained the order sheet before the trial court. Till date, I have paid,
No,
Lordship.
he says another 30,000 doesn't matter. Yes, next. Please come to the
Yes.
order. What is the income of the husband?
Lordship, 45,000, my Lordship. Lordship, in this case, my contention is, my Lordship, Lordship, the main petition is for maintenance of rupees 25,000, Your Lordship. Lordship, both the petitioner and the respondent, the marriage was took place in the year 2017. Both the petitioner and the respondents were divorces and they are remarried, my Lordship. And there was no issues. The petitioner has got an aged mother of 75 years and he has got a son, Your Lordship. The same was intimated to the respondent before marriage. Lordship, she has stayed only for 1 month. Thereafter, Lordship, she left the company of the petitioner and she filed the petition for maintenance. and she has filed in a complaint, my lordship, against the petitioner for 498A, my lordship, other offences also. My lordship, in the main petition is for maintenance of rupees 25,000, your lordship. I have produced the entire order sheet, your lordship, and I filed objections to the main petition, and IA number 2 is filed for interim maintenance of rupees 20,000, your lordship. My lordship, there was no opportunity for me.
25,000.
Main petition for 25,000, interim application
20,000.
20,000, your lordship. I have filed objections to the main petition. So far as IA number 2 is concerned, my lordship, no opportunity was given to me to file objections to the IA number 2, your lordship. Okay, I have produced the entire order sheet also. My lordship, now the
Where is that? Let's see first. Where is that? That
Worship,
order sheet.
Worship, order sheet at page 65, your lordship.
Hmm.
Page 65, the relevant portion at page 68, your lordship. That is on 12/4/2019. So and so filed NOC Wakalat, BMC report received, matter not settled. For objections to the main petition, call on by 27/6/2019. Worship, again on 27/6/2019, finally for objection statement to the main petition and IA number 2. Call on 1/8/2019. Your lordship may come to page 69, your lordship. That is 2/11/2019. Respondents counsel filed objections to the main petition. Objection to IA number 2 taken as not filed. On that day, I filed an objections to the main petition. And my objection.
No, what is this not giving an opportunity? Court will eternally wait for you that you will come and file objections.
No, my contention on that day I sought time.
Please wait. It started on 21/1/2019. You asked for time. No, when is the order passed? On 26/2/2021. How much time you require?
On that day, that is on 2/11/2019, I filed objections to the main petition and sought time for my lordship to file objections to the IA number 2, your lordship. That was not given.
How many times the matter underwent adjournment? If you not filed
Lordship,
it, it is not the court's problem.
No, lordship, it was posted for, now kindly see, objections to IA number 2 taken as not filed for petitioner evidence. The matter is set down for petitioner evidence, your lordship. That is the reason I am not able to file objections to IA number 2. For petitioner evidence by 15/1/2020.
Where did the court say that you can't file your objection?
Objections has not, objections to IA number 2 taken as not filed.
Before that?
Before that, it was urgent for filing of objections to the main petition and as well as IA number 2.
So you should have filed it.
That is my submission on that day. I filed objections to the main petition and sought for time to file objections to the IA number 2, your lordship.
Yes.
My contention is, my lordship, no opportunity was given.
How much you are ready to pay?
In fact, my lordship, now she is not willing to join with the petitioner. My lordship, we have an offer, my lordship. We are ready to pay. An offer was given to my learned friend, your lordship, but
what is your offer?
We are seeking from the respondent. We are seeking offer from the respondent, your lordship. That is the reason.
So far, he is not give any offer to what, how much.
You come out with your whatever you want to say.
Before that, not he has produced his salary certificate before the family court. He is trying
what he says is
78,000.
I have no opportunity for my objections. Now again, this matter is sent back for objections. How much time it will take? Ask your client what is that she want, and put forth to him.
Because the lordship, she is not willing to join with the petitioner. That is the reason, lordship, we have given an offer.
He is ready to join the company with the petitioner.
She is ready to join.
Yes.
Lordship, on the last.
Who told you she is not ready to join? She says she is ready to join.
Lordship, before the family court, lordship, she refused.
Tell your client that she is ready to join.
Lordship, I will secure instructions. Before the family court, it was the contention of the respondent, lordship.
Now she is ready. How does it matter? Like,
I will secure instructions.
When that 30,000 you are going to file. pay the arrears of 30,000.
I have secured the entire order sheet, my lordship. I have paid every month without fail. If, my lordship, if any due is a,
Before the family court, there is no.
my lordship, if any due is pending, my lordship, I
Before
am
this
ready.
court only, my lord, on
According to the
17th.
land counsel for the petitioner submits that a respondent submits that as per the interim order passed by this court, the husband has to pay 10,000 as of now. The arrears are 30,000. Land counsel, the petitioner shall pay the arrears, if any, but within 10 days from today. Post this matter on 30th. By the time it is submitted by the land counsel for the respondent is ready to join her husband. He shall get, the land counsel for the petitioner shall get specific instruction in this regard.
And next week, any chart date, my lord.
Next week.
Because the respondent is ready to join the company petitioner. It may be by next week, not any date, and
20th?
19th, yes, please,
20th.
20th.
So for payment, your lordship, need 10 days time, your lordship. That is maybe on 23rd, your
For
lordship.
payment 10 days, post this matter on 20th. Yes, next.
Please.
For hearing on interlocutor application, cell number 34. Bhanu Prasad K.
Petitioner counsel seeks short accommodation.
At the request of land counsel for the appellant, post this matter on no representation for the respondents. Post this matter on November 19th.
Please.
Cell number 35.
Here for appellant, notice has to be ordered. Delay.
Notice to
Lord,
respondent.
I seek for dispensation of notice to 1 to 7 and 11 to 67.
Take that.
Because contesting respondents are 8 to 10 minutes.
A memo is filed to dispense notice to respondent 1 to 7 and 11 to
67.
67, since they are not seeking any relief against them. The memo is taken on record and the notice to so-and-so is dispensed with at the risk of appellant. Registry is directed to issue notice to the remaining respondents. Yes, 36.
36 urgent, cell number 37. H. Kiran Shetty.
Serial number 36, they haven't informed us, my lords.
If they have not informed you.
That's right.
You said that it is coming up for cross-examination today or something.
My lords, their cross-examination is done, my lords. The defendant, they are different.
It's already adjourned, 36.
My lords.
Morning itself it's adjourned.
It's
No, there is no interim order in that. Why are you worried?
But they have to produce the layout plan, which is necessary to prove this case, my lords. As per order dated 22/4/2024, this court had ordered.
We'll see, we'll see. Yes, no orders against you. Why do you bother? Yes, 37.
37. Mahesh Kiran Shetty.
No representation on behalf of the interim order. Any interim order?
No.
No representation on behalf of the appellant counsel for the respondent present. Pose this matter on November 12th. Yes.
Cell number 38.
For appellant. This is a plaintiff who has filed this appeal,
For
challenging the interim.
respondent, Lord, this matter will take some time. Any date may be fixed.
It's
To
already
mutual convenience, because it is
See,
about.
initially what has happened, 39 rule 1 and 2 application was allowed ex parte, my lords.
Anyhow,
Yes,
now
my
it is 4:30.
After the
When do
lapse
you
of
want?
about,
When do you want?
it's next week.
Yes, 20th. At the request of both the councils.
30.
Lord, what is the date? I'm sorry.
20th.
That is
20th.
20th is
Friday.
Friday. Great.
Cell number 39 urgent, at 40. P. Anand.
Hearing for appellant in this matter, lordship. IA 1 of 22, early hearing.
Yes.
Kindly fix the date.
How early you want?
Lordship,
How early you want?
next week maybe.
Pose IA 1 of 22 is fine. To expedite the hearing. Pose this matter on 12th of November for hearing. Yes, next.
41. Delay notice.
Delay notice to the respondents.
Cell number
There is an
40.
order of not to precipitate, interim order is there. May kindly be.
It's already granted.
Yes, ma'am.
Notice is not ordered till.
Not
now.
out. Notice has to.
Notice to respondents, interim order, look at it, if it is there and extend it to the next date of hearing. So without any notice to the respondents,
Fact
in
in
a
the-
delay petition, you have an interim order right from 2022.
No, my lords, in fact, there was an order which reflects in the website, there is an order of notice, but it is not forthcoming in the order sheet, my lords.
First of all, when you come with a condon, with a delay petition, why should there be an order without notice to them? Just 42.
Cell number 42, Kashina JD.
Filed the recalling application for restoration of
Recalling, yeah.
chambers.
Where is the other side?
Petitioner is
C. Patabi Raman.
No representation for the respondent. Post this matter on 23rd September.
last date of hearing also they have not present.
If they are not there, then post this matter tomorrow. Tomorrow.
I said first yesterday.
There are no representation on behalf of the respondent. At the request of non-counsel for the petitioner, post this matter tomorrow. Yes, 43.
Cell number 43.
For the respondent, my lords, my statement of objection for the delay application is ready. I
Your
will
lordship.
file it by serving a copy on them, my lords. My lords may kindly have it next week, my lords.
Your lordship, I'm suffering a warrant. I'm running around Bombay City. The police is
Then
chasing me.
don't, then we'll wait for your reply. Till such time, don't press on the execution.
That's all, your lord.
I will not press on the execution, my lords. There is a lot of areas that, my lords, if I may submit, my lords.
To file objections to the, on the delay application, that is I number 3 of 24. Post this matter when?
Next week, my lords.
Post this matter on next week, on 20th.
Please.
20th.
There is a warrant, your lordship.
That's what, please wait. Not-
My lords, the arrears are
Post
not
this matter
paid, my
on
lords, until
28th.
now.
No, you're not, what are the arrears?
Your lordship.
My lords, it is around 1
On the
crore
condition of
plus, my
depositing
lords.
the amount.
No, your
Yes, my
lordship.
lords. That would be helpful, my lords.
Lordship, he earns only 25,000 rupees. Now
My
now-
lords, I seriously object to this. He has multiple educational institutions. He was in the merchant navy. The educational
How much-
institutions
This
are
is
all
my
pertaining
case.
to merchant
1
navy
minute,
institutes.
1 minute. Now, when is the order passed?
Your lordship, the order was passed
10/10/2023.
23.
Almost after a year, you
Your
have come to
lordship,
this
the
court.
reason is this person suffers from epileptic attacks and he is literally at the verge of being called crazy. There are two phases of this case. One prior to 2010 November, when he was in merchant navy, he was earning well. He used to earn about 5-6 lakhs. He suffered a massive near death accident. And after that, he is not even able to stand up properly, talk properly, coherent. Whatever certificates he had for being employed, he has lost it. These certificates have been terminated. Not that he is just lost. Today is totally
You have the evidence
Yes.
for all that?
My problem is
Post
this.
this matter at the request of non-counsel for the
My
respondent
lords,
on so and so, on 27.
No,
Till
your
su-
lordship, tomorrow,
till such
he is
time-
literally
till
out
su-
of,
Till such time, the respondent shall not insist for, shall not press for the execution. Yes.
Cell number
my lords, if
44.
some arrears are deposited, my lords, meanwhile.
We'll see, he's saying something, we'll see.
44,
My
Ajesh
lords, I
Kumar.
appear on behalf of the appellant, my lords.
44.
44 on behalf of the appellant, my lords. If any date may be fixed for hearing, my lords.
Why is it coming up under this caption for orders?
Please finally.
Who's final hearing?
Final hearing.
21st October. Yes,
My lords, I'm so sorry, I couldn't hear that.
21st October.
Obliged, my lords.
Dismissal, all those matters.
List number 3, serial number 1 now. Serial number 1. List number 3, serial number 1.
Milord, I appearing for the appellant. I pray for 2 weeks. I pray for 2 weeks, Milord.
You were not present on the other day when the matter is called.
Sorry, Milord. Sorry, Milord. Sorry.
The appellant is, the delete from the caption dismissal. A week's time is granted for complying the office objections in default. Same, without further reference to the court, the appeal will stand dismissed. Yes, two,
Number 2, V.
Anand.
Anand.
I'm sorry, madam. Weeks time may be granted.
Yes, a week's time,
Please.
default order.
Serial number 3, Bairegowda. Serial number 3,
As there was no representation on 11/9/2024, this matter was directed to be listed under the caption for dismissal. Today also there is no representation. Appeal is dismissed for non-prosecuted.
serial number 4,
Why this advocate is not practicing? Prashant B.R.
Prashant B.R.
Prashant B.R.
B.R.
Several matters are coming, every matter is getting dismissed, but still they are not coming. That to land acquisition matters. The matter is posted for dismissal, as there is no representation on 4/9/2024. And today also, in the afternoon, at 2:30, as there was no representation, the matter was again called in the evening at 4:30, 4:40. Even at this hour, there is no representation. Accordingly, all these appeals from 4 to end,
15, under end.
4 to 15, are dismissed for non-prosecution.
And 18 to last.
No, there are dates are there. Some are 4,
Eight-
some
eight-
are 9. Look at all that.
Yes,
Yes.
18 to 27. Serial number 16, Sanjay G.
Same
16,
order. No
Same.
representation. This is on 11/9. Next 17.
17,
This is also on 11/9. Dismissed. 18.
serial number
This came up on 4/9.
18 to
So same Prashant B.R.
Oh.
from 19 to
serial number
23.
28, Jagdish J.R. 28. ಅದು ಎಲ್ಲ common ಇದೆ.
I appear for the petitioner, my lord. Yesterday it had come due to
Which one?
mistake. 28.
28.
I appear for
Weeks
weeks
time. Weeks time default. Yes, call the passport.
Passed over matter, list number 2, serial number 2.
What are your instructions?
Sorry, my lord, I was in another court.
So what are your instructions?
Only 2 points I will, my lord, make out. Lords may kindly take the reasons for filing the application, my lord. Page number 85,
Page number 80.
85, my lord.
Yes.
Lord, please see para 3.
Yes.
Lord, last 6 lines, the plaintiff with malafide intention of preventing us from filing necessary applications and seeking appropriate remedies, went ahead and put up a hoarding that is larger than the one before on 2/12/2023 by gathering about 30 to 40 antisocial elements, though there was no permission for him to do so. Then please see para 5, my lord. I state that the children of the defendant intend to start their business in the application scheduled property. However, no brand is ready to grant them any franchisee unless the board put up by the plaintiff is removed from the first floor. It is not possible to begin any business unless they can remove the wall or modify the floor according for the purpose of-
Exactly. Basing on this, when the matter started,
Yes,
the
ma'am.
court was in favor of the defendant.
Yes,
They
ma'am.
said that they have vacated the first floor
Yes,
and they're
ma'am.
doing the business on the ground floor. This was it. Now,
thought-
that letter which is referred to,
ma'am.
basing on that, they have vacated the first floor and they have come to the ground floor.
Yes,
With
ma'am.
that arrangement,
Yes,
that
ma'am.
50% of the frontage, they'll have the signboard.
Yes, ma'am.
So how can you ask for such a relief now?
Now, what has happened subsequently, my lord, is we filed an application, my lord, for removing the wall, on which, my lord, this signage or hoarding has to be affixed.
No, that amounts to, no, that order.
That order,
That
my
order
lord,
has been,
set
it's against,
aside, set aside.
that's
set aside.
against you.
Yes, my lord, that, no, the,
So you cannot remove the wall.
no, wall has been removed. Physically, there is no wall. Order was made in my favor.
Justice Krishna Kumar's order is what?
My lord, setting aside the order made in my favor.
No, yes.
So
By the
therefore,
time you remove.
by the time it is removed, then my lord, now my lord, therefore my lord, it will be only of academic exercise because my lord, now the application filed by me is, please direct them to remove the hoarding. My lord, whatever wall was there, If they had, my lord, fixed it according to that, my lord, it would have been different. My lord, there is some,
No, you please tell the court, what is that fixed, they want that they will have. Now, the whole purpose of filing the suit, granting orders, all this litigation, the whole purpose is frustrated by this.
now, my lord,
Only to that extent, what you say that it was this much, whatever it is you specify, let them come up with an affidavit that it will be retained as per that.
now there is no wall, my lord. Now, my lord,
Be constructed.
there is no wall. Now, my lord, there is a tenant. Now, my lord, there is another person who is occupying the first floor. He has put up his signage. Now, my lord, it will amount to undoing that. Now, my lord, no prejudice is caused to me. Of course, on facts, my lord, some facts may be against me. But, my lord, he has got ample space. Please have a look at his own photographs. I don't.
It's all about your contract, it's not about what is right, what is wrong.
Yes, my lord.
It is
Now,
about
my
the
lord,
agreement between the parties which they
now
want to
assuming, my lord, he.
enforce before a court.
Yes, my lord. Assuming, my lord, he is now prevented from, my lord, showing any advertisement because there is already a tenant. He has put up his signage. My lord, he has come up with his showroom. Third party rights will be.
No, it is like this. He goes to the court, you will get an order in his case.
My lord, that is because, my lord, as I told yesterday, my lord, the wall was only little bit, my lord. He goes, my lord, misuses this order and puts up a larger hoarding.
No, that's incorrect.
If that is the case.
Therefore, what the court did was, my lord, since it cannot be cut,
No,
they
no.
said remove it.
Then you can tell the court that this is what it is. After the order, they have done something else.
No, that is the application I filed. That is precisely the application. I'll just point out, my lord. Please have a look at that application.
Then let them keep as it was earlier.
Now there is no wall, my lord. It will have to, my lord, amount to building a wall. If wall is built, my lord, there is an existing tenant. Now, my lord, all this emanates because, my lord, there is some, my lord, landlord-tenant relationship, my lord, issue. I have already.
Necessarily, you have that letter you have signed.
My lord, it is not that, my lord, we want to trouble them. My lord, in good faith, we did it. They said, my lord, they will vacate. They did not vacate.
You have given him this thing saying that you vacate it and we will permit you.
My lord, it is like, my lord, Mahabharata Karna. When, my lord, he came and said, give me your Kaucha and Kundla. My lord, Karna did not anticipate that this was the purpose. Only subsequently he realized, same is my position, my lord. In good faith, my lord, we did it. And, my lord, there was understanding that certain amounts have to be paid. He said he will vacate the ground floor also. Business is not doing well. Till then, my lord, we were all very happy together. Subsequently, it does not vacate. Eviction notice is given. I file a suit for.
Court orders cannot be utilized for somebody's undue advantage.
No, that is true, my lord.
Tomorrow at 2:30 for dictation.
Lord, may I just request it for, my lord, Wednesday? I'll just place, my lord, the material also. I'll place it now itself. My lords may dictate the order. I'm not coming in the way. Tomorrow there is some inconvenience, my lord, because tomorrow, my lord, one of our colleagues, my lord, is getting married. So therefore, my lord, office will be there, my lord. Only for that reason, my request for Wednesday, my lord.
Pose this matter on Wednesday at 2:30 for dictation.
Yes, ma'am. I'll just place the pleadings, my lord, in the eviction suit, where this letter is explained under what circumstances we gave the letter, how that letter is. My lords asked me yesterday, I was not able to answer. I am placing how, my lord, the letters are floated. I'll just, my lord, place it, give a copy to the other side. If there is any citation, my lord, I will pass it on to the other side and place it before the. I'm grateful, my lord.
Yes, not yet come.
ಮೇಡಮ್ ಚೇಂಬರ್ ಹತ್ರ ಹೋಗ್ಬಿಡೋದು ನಾವೀಗ ಚೇಂಬರ್ ಹತ್ರ ಎಲ್ಲಿ ಮೇಡಮ್ ಹಿಂದೆನಾ ಇಲ್ಲೇನಾ ಮೇಲೆ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ